Good afternoon, folks. My notes indicate here that we have a total of 7.5 hours of requested argument. And if I were to grant that, we would be here into the evening, and I imagine you folks do want to get home. So what I would ask is please ask for the time that you want to convince us of your most important points. You're not going to get to all your points, but the points that you think that are most important, bring those up. You do not need to educate us. We are a hot bench. People versus Centron. I'm sorry? 4, 2, and 4. Asher versus New York City Department of Education. It looks like you've scared off your adversary. Would you wish to submit? Yeah, we wish to submit. Okay, so I will take that on submission, and I do want to note that Judge Scarpula is recused from this case. JBT Children, submitted. Boric versus Seidman. Respond in 4 minutes, please. Okay, well, you too, sir, have scared your opponent away. Do you wish to submit? If the panel has no questions for me, I will submit. I think we're good. Dewald versus Dewald. So you wish to submit? Okay, so I think we'll take it on submission. We're familiar with your arguments. People versus Elroy Robinson. 5, 2, and 4. People versus Purera. 5, 2, and 5. Bolero Corp versus AIG. I'm sorry, you want 6, sir? 6 and 4. Okay, 6 and 4. And the arguments are pretty similar. So how I really don't want to. We don't need to hear repetitive arguments. So do you each want to argue separate points? Have you discussed that? Yes, we have. Okay. So what do the respondents want? So on behalf of AIG and Everest. Okay, so 6-4 AIG, I'll give you 7 minutes, Landmark 5 minutes, and Star 2 minutes. Iraze versus Bradhurst Retail. 4, 2, and 4. The Law Office of Cyrus, Jubin. 4, 2, and 2. McStaka versus Brisk. Submitted. Oh, sorry about that. I'm sorry, you repeat? Yes. 4 and 2, you got it. You got it. 4, 2, and 4. People versus Arzu is submitted. Siebel versus Scola. 6, 2, and 6. People versus Wells. 6, 2, and 5. Smith versus Kiby Hotel. 5, 2, and 5. Kadem versus Stonehill. 5, 2, and 5. People versus Johnson. 5, 2, and 4. Sogoloff versus Sogoloff. 5, 2, and 4. Augustana versus City of New York. Okay, we'll take it on submission. People versus Kirk. 4, 1, and 4. And final case is Breton versus Dishy. And that is submitted as well. Okay, first case up is People versus Centron. You may proceed.
Thank you. Good afternoon, and may it please the court. Jane Merrill for appellant Stephen Centron. Mr. Centron was assessed a mere 40 points on the risk assessment instrument. Despite this exceptionally low score, the SORA court upwardly departed to deem him a moderate risk. The basis for an upward departure must be both proven by clear and convincing evidence and not otherwise be accounted for by the RAI. The grounds proffered by the prosecution in support of their request for an upward departure met neither of these criteria.
Counsel, the probable cause affidavit, why is that not sufficient for clear and convincing evidence?
Yes, Your Honor. That affidavit provided just one paragraph about the previous arrest. It did not actually connect the arrest to the underlying conduct, and it did not provide any of the evidence that it actually cites. So that affidavit cites a search warrant and a TMZ article, neither of which were actually provided to the SORA court. And as standing alone, that doesn't show what the arrest was for, and it doesn't provide clear and convincing proof that this actually happened. Clear and convincing proof is a very high standard, the highest standard in the civil context, and all we have here is one paragraph written 10 years after the fact, citing to evidence that was not actually provided to the court. Even if Your Honors believe that that is sufficiently made out, criminal history is a factor well accounted for by the risk assessment instrument in several categories. And because of that, this court has held repeatedly that factors already accounted for by the RAI are not a proper grounds for an upward departure unless someone's criminal history is truly extraordinary, extensive, or serious. And the 2011 allegations are the sum total of Mr. Centron's criminal history before this arrest. That's simply not extensive, extraordinary, or
Your adversary
serious.
would probably argue that as an uncharged crime, there was only so much that could be provided, but it's a sworn affidavit from the law enforcement in, was it Pennsylvania?
That's true. There was more that could have been provided here. This was a sworn affidavit from a Pennsylvania police officer, possibly discussing a 2011 federal arrest. So there were certainly evidence from the federal authorities that would have supported this arrest. I think we would be in a very different position if we had those documents in front of us, certainly on the burden of proof. Still, we come up short when it comes to whether this was actually accounted for by the RAI, and I would submit that it was accounted for by the RAI.
In what way do you think it was accounted for? I mean, this is pretty serious speech sent to a 12-year-old girl. What way do you think that that was accounted for, who the allegation is he's still abusing today?
Yes, Your Honor.
Tell me where you think it was accounted for in the RAI.
Yes, Your Honor. So there are three factors in the RAI that account for criminal history. Under convictions, the recency of the conviction.
Well, this wasn't a conviction, we agree,
Correct.
so it's not accounted for there.
Correct. And so under the board's own judgment, under their guidelines, this does not rise to the level of meaningfully reflecting on someone's risk. So it's
Wait, is your position that uncharged crimes can't be used? Because I don't think that's what the case law supports.
no, Your Honor, my position is not that uncharged crimes can never be used. My position is that uncharged crimes can only be used both when it reflects a quite serious, extensive, and extraordinary criminal history, and it's proven by clear and convincing evidence, and that the circumstances, the individual circumstances, do not leave it accounted for by the risk assessment instrument. It will be, in some cases, properly scored points. But here, the board's own judgment that this was not worthy of assessing points does reflect something about the risk. So no points were assessed with regard to this uncharged
And he
conduct.
threatened to rape and kill the 12-year-old, right?
He did send messages.
And he is still messaging that person today.
I-
So that behavior has not abated.
I don't think it's correct that that behavior has continued today. It continued till the point of his arrest in the underlying conviction that we're talking about.
Which is what year?
Which was in 2019, I
We're
think.
talking about there were 7 years that conduct didn't abate, right?
That's correct, and I think that's,
And you think, where do you think that was accounted for in the RAI?
I think that the board's own judgment in weighing what actually reflects on someone's risk makes this accounted for by the risk assessment instrument. And I say that not to diminish what happened here. All of this is very serious. Of course it is. We're talking about a registrable offense. But what is different here is that after that 2011 arrest, Mr. Centron was not prosecuted, he was not indicted, he was not incarcerated. So all of those deterrent effects that we typically mark up to a prior conviction, and part of the reason the risk assessment instrument does take prior conviction so seriously is because it shows that there wasn't this deterrent effect.
Thank you, counsel.
Thank you.
May it please the court, Rafael Curbelo for respondent. The 2011 arrest was uncovered by the police officer who was doing the investigation on the 2019 and 2020 messages that defendant was sending to a 12-year-old dancer.
I mean, but counsel, at the time of the hearing, there wasn't anything other than this particular, as your adversary put it, one paragraph inside the probable cause affidavit. If we look at the Epstein case that came out of this department, it was so much more detailed. We're not saying that probable cause affidavits aren't sufficient, but this was, what is this?
Well, in this court, in People v. Epstein, this court held that a detailed probable cause affidavit did constitute clear and convincing evidence.
Yeah, but that affidavit was so much more detailed than this one here.
And didn't they also have various other complainants' information? I mean, it was a much more extensive thing, very hard to compare those two, I think.
Well, I have not seen the Epstein probable cause affidavit.
Okay, but you did read you read what we said about it, and we went through the details in terms of the complainants within that affidavit, saying what Mr. Epstein had perpetrated on them.
Yes.
Correct?
And so what?
So how do you connect that to this case with respect to the 2011 incident?
Okay.
Isn't it apples and oranges?
Well, given how you've described the Epstein affidavit to me, that what the affidavit contained were the witnesses' statements. Here, the police officer had the texts themselves, so he had the crime itself, not someone else's account of the crime. So I think it makes this affidavit more powerful in that sense, because he's got the crime itself. The messaging is the crime, and that's what he has. Not some witness's account of what happened, but he has the crime
But it's
itself.
based on a TMZ article, right? What is TMZ, by the way? It's some sort of
It's some
tabloid?
kind of tabloid. I don't know what the initials stand for. But when he executed a search warrant,
So how reliable is something, is that writing?
standing on its own, probably not very reliable. But when he executed a search warrant in 2020, In his investigation of this case, he discovered that the defendant was still messaging that.
But it doesn't say, he doesn't give a lot of detail about that. And the fact of the matter is, we have a clear and convincing evidence stand. It may be that he was still saying the same things, but that affidavit doesn't express that.
Well, the affidavit says in 2011 he was saying, I'm going to
Yes,
rape,
but I'm
threatening to
talking
rape
about-
and kill. So let's assume,
Well,
for
we
the sake
can't
of argument,
assume because we have to go based upon what's inside his affidavit, and it just says that he routinely messaged the singer. Routinely messaged could be anything.
the only nature of his investigation was into threats of raping and killing these minor dancer and singer. Nothing else was included in there. I'm sure the defendant texts and messages a whole slew of people throughout the course of the day, but the only focus that the officer had in his affidavit was information that pertained to the nature of his investigation.
Except it wasn't very detailed. That's the problem. It wasn't detailed.
Yes, detail could be a matter of degree. I would
It is
argue
what
it
it
was
is,
detailed
right? We
enough,
agree.
that it was detailed enough.
Yeah, but to meet the clear and convincing standard, you know, it's not preponderance of the evidence, so it's a higher burden on you.
Were all these
Well,
factors
then in-
considered by the court? Were all of these factors considered by the court in making the determination?
They were all before the court. This package was before the Sora court. And so the Sora court was privy to all of this information. And it also was privy to the fact that in November of 2011, only 2 months after the alleged threats to the dancer, the defendant was arrested by the FBI. And so unless there's some other allegation that we don't know about, we have a good faith basis to believe that he was arrested by the FBI because of the threats to the dancer in 2011.
I'm not sure good faith basis is sufficient. The standard is clear and convincing. In any event, let's hear from your adversary.
Thank you. I'd like to turn briefly to the totality of the circumstances here, which really does warrant a level 1 adjudication. First, as I began with, Mr. Centron was assessed only 40 points on the risk assessment instrument. That's truly an exceptionally low score. And even if points had been assessed for all of the things that the prosecution based its...
Do you want to talk about the kinds of messages he was sending this minor? We're talking about totality of the circumstances. Were they graphic? Did he threaten to rape a child?
In the instant offense, Your Honor?
Yes.
Yes, Your Honor, he did. That is absolutely correct. He sent those messages. He was convicted for having sent those messages. I think what's important to note is what's not present. What's not present is Mr. Centron actually making contact, either physical or digital, with the minor in question.
And you think that that makes the crime less serious?
No, Your Honor, I don't.
Well, then what is the point of even raising that?
I think it is important because it bears on the nature of this offense, which is one of the factors considered by the totality of the circumstances. The truth is that had this conduct occurred purely within the state of New York, had Mr. Centron been prosecuted and convicted in the state of New York, he would not be registrable because New York does not consider this a sex offense. So that is why I bring up the nature of the offense, not to diminish it because it is very serious. I wanted to also turn to the impact of this adjudication. Mr. Centron will very likely be rendered homeless by this adjudication. It is true that there is some possibility that he will not, but eviction proceedings have been instituted against his family. The purpose...
Will it matter whether he's a 1 or a 2?
Yes, very much, Your
In
Honor.
what way?
The federal law regulating this prohibits admission of people subject to lifetime sex offender registration.
New York State doesn't comport to that.
I would submit, Your Honor, that it does based on NYCHA's own website and the fact that eviction proceedings
I mean, if
have been
people are
instituted.
evicted from NYCHA for less severe criminal contact, I mean, I don't necessarily know if that's the hat we want to hang, the nail we want to hang our hat on. I don't know.
Understood, Your Honor. And I've seen criminal cases where people are evicted, but just just to wrap up very quickly, I think the timeline here is really telling. Mr. Centron was arrested in 2011. He wasn't evicted. Mr. Centron was arrested in 2021. He wasn't evicted. He was released from prison in 2021. There were no eviction proceedings. It was only after this level 2 lifetime sex offender adjudication that there was ever any whisper. So I think it's very clear based on the circumstances that this adjudication did weigh in NYCHA's decision to institute eviction proceedings. And so based on all of that, I would ask that you adjudicate Mr. Centron a level 1 registrant. Thank you.
Thank you. Mr. Dewald, please step up. It's my understanding that you come up. You wish to make argument, correct? Okay, I'll give you 2 minutes, please.
Good afternoon, Your Honors. Jerome Dewald, in pro per. This is a pendente lite matter where there are no kids, no assets, nothing but debts, and some modest income. The court below made numerous fundamental errors that demand reversal. Among these, first, it accepted allegations as fact without a hearing. Second, it created a novel punitive litigation metric without any standards. Third, it issued unconstitutional threats that chill access to the courts. McKinney's Session Laws of New York, 2010, notes that when enacting the guidelines in DLR 236, the legislature declared their very purpose was to, quote, address, quote, the profound inconsistencies and unpredictability in the calculation of temporary maintenance awards, which had, quote, created increased litigation and difficulties reaching settlements, unquote. The court didn't even try to balance the hardships. It opined that the presumptive guidelines explicitly set by the legislature were, quote, truly burdensome and, quote, a saddle, unquote, on the plaintiff. This is in the record on appeal at page 33, second paragraph. When in making pendente lite awards, courts must adhere to the clear statutory framework established by DLR 236 to ensure consistency and predictability. In relying on allegations as fact without any proof, as it admits in its opinion, quote, given the alleged history, unquote, this is the record on appeal at page 33, subverts the very purpose of the guidelines by reintroducing the type of unpredictability and inconsistency that the legislature explicitly sought to eliminate. A 75% downward deviation from the presumptive guidelines, unsupported by factual findings, creates a perverse incentive. When the more moneyed spouse pays the full presumptive amount during the proceedings, it has a natural motivation to move efficiently towards settlement or trial. Allowing dramatic reductions based merely on untested allegations at the pendente lite stage removes this incentive and rewards delay, resulting in, quote, increased litigation and difficulties reaching settlements, unquote. The legislature was trying to prevent.
Just finish up, sir.
Okay. It signals future litigants and their counselors that this kind of tactic is effective in dramatically reducing their interim support obligations and unfairly gaining leverage over the less moneyed spouse, particularly those with marginal incomes at the outset. And I will wrap up. I ask this court to, among other things, reverse the pendente lite award and remand with clear instructions to apply the presumptive formula or, at a minimum, require detailed findings based on credible evidence that justify any deviation. Thank you so much, Your Honor.
Thank you, sir. People versus Robinson. You may proceed, counsel. You may proceed.
Good afternoon, and may it please the court. I'm Ji-hyun Rim with the Legal Aid Society on behalf of the appellant, Mr. Elroy Robinson. Your Honors, Mr. Robinson does not represent a level 3 risk to the community. The present case was a complete aberration from Mr. Robinson's law-abiding history, and since Mr. Robinson committed his first criminal offense at 48 years
Isn't the
old.
SOAR court's determination entitled to great deference?
Your Honor, the standard of review here is improvident exercise of discretion. And so, yes, the SOAR court does have discretion in this case, but our position is that the hearing court improvidently exercised that discretion in granting this upward departure and not considering the mitigating factors. I'd like to begin by addressing sort of the gross overassessment that happened here. Both the board and the Court of Appeals recognize in Gelati that the RAI leads to overassessment because it was designed for contact offenses and not in the child pornography context. That's why the board came up with the statement factors. They wanted to flag patterns to watch for when assessing the risk of reoffense in cases like this. And Mr. Robinson just fell short of any of these benchmarks that the board set out and was overassessed by the court below. The prosecution's main argument for an upward departure hinges on basically the nature of the images. And this really speaks to
And the nature of the images is frankly shocking, right?
Yes, Your Honor. We're not diminishing the seriousness of the content.
No, I
here.
understand that, but the underlying conduct is shocking.
Yes, Your Honor. The underlying conduct is shocking, but in the context of the RAI and sort of how the board sees things, this actually speaks to the weakness of the prosecution's case.
So how do you think that the board took into account that your client had thousands of videos and of pictures and videos, and I will just say one, 15-minute and 41-second duration video depicting an adult male exposing himself vaginally penetrating a girl approximately 4 to 6 years old, anally penetrating the girl while the girl cries during the act and ejaculating into the girl's face and stomach. And your client admitted to masturbating to that video, right?
Yes, Your Honor.
Where in the RAI is that taken into account?
Well, first, I want to speak to the nature of the images.
I just want to, I would love for you to answer my question. Where do you think that that's taken into account, your client's behavior in the RAI? What section takes that into account?
It's true. Sadomasochistic content is an aggravating factor.
Of babies?
Yes.
That you're, right?
Yes,
So
it's an aggravating
again,
content.
where do you think that that was taken into account in the RAI?
If I may try to reply, Your Honor, the board is looking for a pattern of behavior to indicate a heightened risk of reoffense. Here, the prosecution is focused on 10 sadomasochistic images. So that's 0.002% of of everything he had in his possession. And so it actually doesn't indicate a particular pattern or that he was actually actively seeking out sadomasochistic content. It shows that there happened to be 2 downloads of large files, admittedly, but it shows that it happened to be part of that file, not that he was actively seeking it out. And that's sort of...
We have a lot of cases recently, I'm sure you would have read them, coming out of this department where the nature of the photographs being so violent is exactly why we reason that the trial courts were correct in doing an upward departure or not granting the downward departure. So we've already addressed that issue. Why is this different?
This is different because it falls underneath the benchmark of what would constitute a heightened risk of reoffense. He has far less than the 30 to 50 images that the boards sort of based their position factor on. He had 10. It was 0.002% of everything he had. He was not seeking it out. And combined with the totality of circumstances, combined with the fact that this was his first criminal offense altogether at 48 years old, the fact that he's lived a law-abiding life, the fact that he's admitted guilt, immediately accepted responsibility, and went straight into treatment, all of this sort of goes against a heightened risk of reoffense. It actually points to the opposite way. And just to go back to the number of images question, number of images was already taken into account under factors 3 and 7 as per Gelati and Johnson, so it really can't be the basis of an upward departure. And I want to emphasize that the board has set out a benchmark number of 10,000 images as indicating a heightened risk of reoffense, precisely because they've encountered so many cases like this where they've considered the difference between pressing a button and amassing a collection over time. And so according to the board, 2 downloads or even 5,000 images is not enough to indicate heightened reoffense. Thank you.
Thank you, counsel.
May it please the court, Larry Glasser for the respondent. In this case, the SORA court appropriately and explicitly cited and applied People v. Gelati and the three-step Gelati test in determining that defendant's request for a downward departure was unwarranted because the factors they cite were properly accounted for in the RAI, and conversely, the factors cited by the people, the aggravating factors, were not accounted for in the RAI. Turning to those factors, as the court found, the extreme number of images and the graphic nature of the images are not
How
accounted
do you respond to your adversary's point that the sadistic, there are very few sadistic pictures and videos?
First of all, turning to the board's position statement, they did say that the nature of the images, i.e. sadomasochistic images, is a factor. And it is not that these were the only 10. I want to be clear, there's no evidence that these are the only 10 out of the 5,700 images that are sadomasochistic. If you look at the complaint that was introduced into evidence at the SORA hearing, that describes several images which are different from the one, or videos that are different from the ones the prosecutor described on the record at the SORA hearing. And those were simply the 10 that the defendant allocated to as part of his allocution. So it wasn't, there's no indication in the record, these are 10 videos that are an aberration from the other 57.
How long had he been collecting these? More than 6 months, correct?
Approximately 6 months.
This wasn't like a one day, let me just download all this stuff, right?
Correct. There were 2 incidents charged in the felony complaint. One was, I believe, July of 1 year. Notably, that included charges of promoting these acts because he shared them on a computer system. And then 6 months later, January of the next year, is when he was found in possession of the majority of the images. And as for the nature of the images, as Your Honor had said, not being accounted for in the RAI, this is very clear-cut example of that, because not to minimize the example I'm about to give, but if the defendant had 3 naked pictures of 9-year-old girls, simple nudity of a 9-year-old, he would be adjudicated the 80 points. He was adjudicated because those are 3 or more victims, those are under 10 years old, and they were strangers. So without getting into Your Honor's repetition of the depiction of these pictures, they include weapons, they include abuse, they include the victims being bound, they include a dog kennel. The nature of these images are clearly not encompassed in the 80 points.
And would a level 3 assessment restrict him from accessing dating sites and other sites where people tend to look for underage victims, or at least that's what the
Yes.
The police have said, right?
Yes, Your Honor. So in this case, counsel made much in her brief of this being a non-contact offense versus a contact offense. There is still, especially in this day and age of the internet, a very significant risk and very ease of someone repeating a child pornography, seeking out, obtaining it, promoting it on the internet. So, these adjudication does directly go to reducing his risk of reoffending because, as the SORA court found, the harm to the children depicted in these images was vast, and it would be vast if he reoffended.
Any evidence that this would escalate to contact offenses?
There's no explicit evidence that he personally tried to escalate it, but he did admit, again, not just downloading them, but promoting them on the internet, and he was indicted for that, so there was clear and convincing evidence.
And receiving sexual gratification from the images.
Yes, I was about to say that, Your Honor. He did admit in his allocution, which was admitted into evidence at the SORA hearing, uncontested on stipulation, that he was aroused by these images and masturbated to them. So while I'm not saying he took any steps to do this, it's not inconceivable that he would have or could have acted further on them.
Thank you, counsel.
Thank you, Your Honors.
I just want to clarify some points. First off, Mr. Robinson downloaded his first file at the end of July, and then on the 28th and then 29th, and he was arrested on January. So it was actually like below the 6-month mark. And also, he didn't share or upload anything. It appears once in the prosecutor's letter that he uploaded and shared, and then it doesn't come up again anywhere in the minutes. In the complaint, he says he's downloaded and viewed it, and he didn't mean to distribute any of it or share any of it. So I don't really know what substantiates that. And third, the monitoring. His internet activity would be monitored regardless of his level. The sort of main difference is how often he would have to come in person to register. And I just want to remind Your Honors the point of SORA. The point of SORA is a 3-tier system. It encompasses all sex offenses, not just child pornography, and it tries to provide the public with accurate information about the registrant's risk. It's not meant to punish, it's meant to inform, and it's a forward-looking system to try to accurately do that. Your Honors have seen many SORA appeals at this point and many child pornography cases. A 3 is a serious overassessment of Mr. Robinson's risk to the community, and affirming that decision would not just be an injustice for Mr. Robinson, but really a disservice for the SORA framework and public safety. At 48 years old, this was his first offense. It happened within a very, very short period of his life, indicating that this was isolated. There's absolutely nothing to show that he wanted to elevate this or wanted to elevate this, and he does not pose the most serious risk level to the community. We ask this court to correct this error and at a minimum reverse the upward departure. Thank you.
Thank you, counsel. Thank you both. People versus Purera. You may proceed, counsel.
Good afternoon. For Jairo Purera, Office of Appellate Defender by Christiana Prager-Lee. Here, a 1-year sentence reduction is appropriate where these were Jairo's first offenses.
Counsel, people were offering 8 and 2.5.
Yes, Your Honor.
And then your client's counsel at that time negotiated 6 + 5.
Yes, Your Honor.
Which is why we're here.
Yes,
today,
Your Honor.
Based upon something that your counsel negotiated.
And I would ask this court not to hold the fact that his lawyer asked for 6 years against him, that this court has the power to look at the facts anew, look at the fact that this was a negotiated plea anew, and as this court did in Sparks.
Wasn't it favorable to the defendant? I mean, it's 1 year above the minimum, correct?
Yes, Your Honor, this is 1 year above the minimum,
Oh, it's
and the
a
minimum is
negotiated
appropriate
sentence.
here.
Hold on a second. Negotiated sentence that's favorable to the defendant.
Yes, Your Honor, and as this court did 2 months ago in Sparks, you reduced to the minimum of 2 years in that case by 1 year, where the facts in that case required this court to do so.
Well,
And we would look at
each one of these cases is unique in its facts, and we look at them individually. What should we look at here? I mean, this is a possession of a firearm, a loaded firearm. What should make us look to reduce this sentence? What are the factors here?
Your Honor, in this case, Jairo was a young adult, a young man whose life had fallen apart. He was forced to return home after the COVID-19 pandemic from college, where he had found safety. He had seen a close friend die by gun violence and was forced to return home to the same streets that he saw months later another friend die by gun violence. He had not received any help for his untreated mental health issues that he had been suffering since a child. He had not received any help for his substance use, which he was using to self-medicate for those mental health issues. And considering these facts and the fact that his co-defendant in this case got 4.5 years, we would ask for the minimum of 5 years here. And
Anything else?
I would just return Your Honors to Sparks, where this court did reduce to the minimum in that case as well. I would also ask this court to look at the fact that he received the maximum post-release supervision period of 5 years and reduce that to 2.5 years, considering that's where.
Don't you think that he is someone maybe who needs supervision?
Your Honor,
Based on what you just said a few minutes ago.
Yes, Your Honor. And I'm not discounting the fact that some supervision would be appropriate here. I would say that 2.5 years is appropriate, where Jairo is looking to return to college, return to Buffalo, and the fact that he would be on extensive supervision for that time would be counterproductive to his future efforts, especially where he has family support, he has a safety network, and a maximum period of post-release supervision, we would argue, is unnecessary to facilitate his release.
Thank you, counsel. You may proceed.
Good afternoon. May it please the court. Margaret Crookston for the people. Your Honors, this was two very serious offenses committed in a span
How
of...
do you respond to your adversary's point that the co-defendant got a more favorable plea?
That is true. The co-defendant pled to a lesser offense and received 4.5 years. However, that co-defendant did not have any adult arrests, so that was his first offense. And more to the point, the defendant here had been released on bail at the time he attempted to kill someone with a firearm while he had a pending case for possessing a loaded gun. So that alone accounts for that distinction between the two sentences between the defendant and his co-defendant. To the point about the mitigating factors, those were all very much considered by the judge, who even specifically noted that in light of his age, in light of all the extensive paperwork filed by the defense, accounting for all of these factors, that she felt that the sentence was appropriate. As it was noted, he did negotiate for the longer term of post-release supervision, and I think that was in realization that because of his goals and because of the fact that he had committed this offense while he was on bail, he is someone who would benefit from a longer period of supervision and maybe less time in prison in the light of his rehabilitative potential.
Did he express any remorse or apologize to the victim or anything in this case?
There is a limited record to show his remorse. He did plea. He did, in speaking to the social worker, note that he is kept up by memories of the offenses, but those seem to be when he was discussing his own personal tragedies and talking about the people he had seen shot and killed rather than the people that he had shot. So a slight distinction there. I would say also in terms of PSR, he is eligible for less is more. So if he complies with those terms, his sentence could be effectively reduced, his term of supervision rather, to 2.5 years. So if there are no more questions, thank you.
Thank you, counsel.
Your Honors, just to respond to the point about less is more, I would just point out that while that does reduce that, he would not have the maximum, hopefully, of 5 years. Any sort of technical violation does not allow you to have that time cut, and very minor violations would set you back under the less is more Act. So we would say, again, that the 2.5 years of PRS is appropriate, or that is what the prosecution recommended. I would also point out that the co-defendant in this case took the plea to 4.5 years after Jairo took his plea, so that was not before the sentencing court, and is a factor that the court should look at.
Wasn't he charged with assault as opposed to attempted murder?
He was charged with, I believe, attempted murder, and
He pled to
but he pled to attempted assault.
But the distinction I think your adversary drew is the fact that your client was on bail.
Yes, and Your Honors, 2 points there. I would just say that the conduct for this offense, the attempted murder offense, is indistinguishable. And as to his other offense, this is a young man who was released right back to the streets where he had witnessed his friends die, that he had not had any sort of
But the first time
treatment.
he had a gun, right? And he hid the gun, and that gun was taken from him, and he was arrested for that gun, and then he went out and got another gun, right?
Yes, Your Honor.
Okay.
And he said that gun was for his safety, and not discounting the rashness of his decisions here by any means, but he was released to the same streets that he felt unsafe, and it wasn't till that he had the intervention of the last years of incarceration that he was able to get his mental health issues treated, that he finally got a diagnosis, that he finally had any sort of medication, that he stopped abusing substances. And at this point, after 5 years of incarceration, we would say that 6 years provides no more deterrence for a man who is facing his first half decade of incarceration. Thank you.
Thank you, counsel. Thank you both. Bolero Corporation. Whenever you're ready, counsel.
I didn't pack light.
Well, I better stop the clock then, right?
Sorry.
It's okay. Take your time. Relax.
Okay. There we go. Okay.
You ready?
I'm ready when you are, Your Honor. Good afternoon, and may it please the court. My name is Peter Halpern, and I represent the plaintiff, Bolero Corporation. This appeal arises out of an insurance coverage dispute between Bolero and several of its insurers. More specifically, this dispute involves two unique provisions which contain wording that is unlike any that has been.
So the provision I would at least like you to focus on is the exclusion of pathogenic or poisonous biological chemical materials. I think the other one probably is more favorable to you, but please address this provision, especially with respect to the issue of discharge. And there are some courts in the country, I understand we're split, have said that discharge through respiratory droplets with COVID in there is sufficient for this. Would you address that?
Yes, Your Honor. And the two provisions I was going to talk about were the affirmative coverages, but it sounds like we're all okay there, so I can move to the exclusions.
That's just my question.
Yes, no, absolutely. And I think, I mean, it is important to keep in mind that there is a specific coverage grant here, but your question is about discharge, right? And that language, discharge, dispersal, release, that has been construed time and time again, both by the Court of Appeals and this court, to be a term of art indicative of environmental pollution and contamination.
In the context of a provision that says more, doesn't say pathogen, but makes it clear that this is a different provision than the ones that the Court of Appeals have looked at, which make clear that they are talking about environmental. And there's nothing about pathogens in those. So how do those cases apply here?
And correct, Your Honor. The only decision out of New York is actually a trial court decision, Genting, in which they did make that very point. They applied Belt to this exact exclusion and found that that's what you have to do under New York rules of construction. I would also highlight this court's decision in VI Tex, which is throughout our briefing. It's an important case because it says, number one, there's no distinction between first and third-party insurance, which is an argument that the other side makes. But also it says that when you're looking at exclusionary language, the way that we interpret exclusionary language is we have to see if it's clear, unmistakable, not subject to any other interpretation.
So why is it not clear and unmistakable in here?
Well, first of all, it's not entirely clear what's meant by a pathogenic, a pathogenic or poisonous biological.
What else could pathogen be? But if you look it up, it's pretty straightforward. It's a very, very common usage term. Everyone, if you look, Merriam-Webster, Black Law, they all agree. It means a virus, a bacteria. There's no dispute about that.
Well, the Genting court didn't agree, but again, I understand that's a trial court and you're not bound by
Okay,
them.
and
But
so
beyond,
I can cite several courts that did agree with that, right?
You're right, Your Honor, but our focus in our briefing and where I think the issue really is here is the word materials, because you have to read pathogenic with materials. If it was just virus, right, and then we had a standard form virus exclusion that said exclusion of virus or bacteria, that would be perfectly clear. But it says pathogenic materials, and so we're trying to understand.
So you're saying that COVID-19 virus is not, it's not a material. Is that it?
We're saying that a material is defined by Webster's dictionary, refers to something in the creating or making of doing something. And so therefore it makes sense that it's something that has to be somewhere and then leave that place, right? And so if you look at that exclusion in its totality, as you mentioned, Your Honor, there is that language that is indicative of traditional environmental pollution language. But once you get beyond that, then you have to understand what a material is. And then when you get beyond that, you get to the carve-back. And the carve-back is the end of that provision, which explains a circumstance in which they provide limited coverage. And the circumstance in which they provide limited coverage is, as they describe it, some kind of accidental release. So if an accidental release could provide some coverage, then we have to think that an intentional release would not provide coverage, and that is a reading that is consistent with release, dispersal, seepage, et cetera.
If we were to read the exclusion as broadly as Landmark does, what impact would that have on the special time elements provision, which in fact does cover for infectious and contagious diseases?
Right. Well, in the first instance, we would argue that our more specific coverage should govern, and that if you look at every single case that they've cited in their briefs, and there are many cases in which this exclusion has been applied without a problem, not one of them has had an affirmative grant of coverage. And as we note in paragraph 25 of our complaint, in November, I believe, of 2020, when RSUI was reporting to its investors about how it was paying out these claims, it specifically had a category for cases in which there was no exclusion or an affirmative grant of, or otherwise, I believe the word is otherwise, an affirmative grant of coverage. So even they viewed this as something very different when it's read in the context of the coverage itself. And we've also included in the record 2 letters from AIG, which paid that coverage, in which they said, when you reading them together doesn't make any sense, you need to find coverage in that instance. And I will tell you, Your Honors, that there are many insurers who are not in this case because they found coverage under that provision, and there are many insurers, as we note in our briefs, who paid under this or similar provisions. So there should be coverage at a minimum under this provision. Now, if Your Honor would like me to talk about the second exclusion, I'm happy to do that.
You have 30 seconds.
I have 30 seconds. I would again refer, Your Honors, to VI text. And again, at the end of VI text, there's a very important point there, which I can't hammer home enough. There was commercially available language, which insurers have been using since 2006, specifically to exclude virus or bacteria without any of the seepage, dispersal, any of that language that we're talking about here. And in VI text, the court said that's important. Now in CRO, the court said, you can't use an exclusion to prove coverage. That's right. But you can use it when you're trying to determine whether or not the language is clear and unmistakable. Thank you very much.
Okay. So who do you have, counsel?
Your Honor, given that...
I'm sorry, who are...
I'm sorry.
Identify yourself and who you represent so I know how much time to give you.
May it please the court. My name is Courtney Murphy. I represent Landmark. Initially, when we opened up, I was going to go second, but since the court jumped straight into the pathogen exclusion, which is mine, we thought it would make sense if I
That's fine. That's
continued with that. And so we're a little out of turn, but we thought it would make sense.
That's perfectly fine.
Okay. As I said, my name is Courtney Murphy. I represent Landmark. And I just wanted to address the court. Yes, the Landmark policy, it issues all risk coverage, but all risk coverage does not mean all loss. We specifically endorsed our policy to change its terms and conditions. What's important and what counsel's brief doesn't really mention anywhere in its opening brief, either by accident or design, is that this is added by endorsement, and that's critical, because an endorsement overrides any terms in the main policy that is to the contrary. So even though you have that special time element, grant of coverage admittedly in that main form, once you endorse it, the endorsement trumps the main form and the endorsement controls. You ask what's the net effect of that to that special time element, it negates it. That coverage doesn't exist any longer.
May I ask you, your adversary says, putting in the word materials changes what would be pathogenic, a virus, right? The word material makes it unclear. And how do you respond to that?
I respond that counsel respectfully has not cited the full material definition found in Merriam-Webster. One thing that we can agree on, and we both cite to, is Merriam-Webster. If counsel continued further in the citation, material also says matters that have qualities which give it individuality in which it may be categorized. I also would like to bring to the court's attention that dispersal, defined in same Merriam-Webster, is the act or result of dispersing, especially the process or result of the spreading of organisms from one place to another.
So the problem is, as you can see, is that you use the same language there that you use in the pollution exclusion, right? Which would make it less than perfectly clear what you were talking about. Why not use language that speaks specifically to that, as opposed to seepage in the ground from pollution or oil spillage or any of the other things? It's the same language from one to another. So that is what counsel is saying, and not unfairly leads it to be unclear what you mean by those terms.
To address your question, Your Honor, the Glynn Court up in Massachusetts addressed this very same issue.
I mean, we have three courts going one way, three courts
We
going the
certainly
other way,
do.
right?
And my point is, in order to inject that type of term of art, what we're not doing is we're looking at the words on the paper. And as Your Honor pointed out, this endorsement is different. It's actually proprietary to Landmark. No other courts have really addressed this issue. And simply because an insurance company has chosen to use words and terms that were used in other endorsements or exclusions that have been enforced comes as no shock.
But the problem is, when I read it, I think both sides' arguments make sense to me. I mean, they're plausible. So that, in my mind, raises an issue as well. Is there some ambiguity here? And what your adversary argues, that when you look at it as a whole, it appears at least, it may be referring to environmental issues as opposed to the virus-related issues.
And to do that would be to inject our understanding of our prior history, which would be effectively injecting parole evidence where it doesn't say environmental.
No, because you have the words seepage. There's a pathogen doesn't seep. You have the word migration, escape. I mean, those words are not clear words about a contagious virus.
And then just to add on to that, in the context of the belt painting case, you know, that describes terms these words, dispersals, discharges, terms of art, and environmental context. If you could just answer that question, I just wanted to add that part.
Sure. Well, they have been in the environmental context, but in this context, what we have here, which is not in those other cases, is the word pathogen. And under our standard rules of construction, we must give every word its intended meaning. And we have to inject and use the word pathogen and dispersal. And when you have a pathogen defined plainly as Webster's does, and we have the dispersal, which specifically speaks to the spreading of organisms, when we apply those regular terms, applying this term in this contract, which is a first-party contract, not a general liability contract, the only conclusion that can be reached is that it excludes all pathogens, which I might add is broader than a communicable disease exclusion.
What about counsel's argument referring to the VI Tech case, which says, well, there was availability of common language that could have been used to draft an unambiguous exclusion, that you didn't use it, and so even though you're making a good argument, he's making a good argument, it's a little bit ambiguous because you could have used better language than language that business people in the trade and in the insurance business know usually relates to environmental and pollution issues.
Okay, the reason why VI Tech doesn't apply here, it's very, very different. Because in VI Tech, you had your affirmative grant of coverage and you had your exclusion both in that main policy. And in that instance, they're competing with each other. There's tension there. Why this is different is my pathogen endorsement is an endorsement. It changes that policy. We're not competing with each other. It's not mutually
But
repugnant.
I'm talking about the actual language that you use, the choice of language that you use. Because we, you know, when it comes down to contractual construction, we're looking at the actual language that you're using.
But my endorsement serves to override and delete that grant of coverage because I'm specifically saying that we do not provide any coverage for pathogens. And I also want to point out, counsel's brief indicated that the endorsement only excludes pathogenic materials. That's not what it says. It says it excludes all loss and damage as a result of pathogenic materials directly or indirectly resulting from any of those things, whether it be dispersal or any of the other mechanisms that it could get out there. And so when we talk about dispersal, seepage, it just is intended to be as broad as possible to show and address any possible means of transmission.
That language can't possibly apply or does not in normal parlance. Look, we're talking about rules of construction.
I know.
So if it's not good, it's against you. And that language, seepage, that kind of language doesn't connect with coronavirus.
But I'm not looking to rely upon seepage. That is just one of a sequence of descriptions of how it can be described. I have dispersal.
And that is what it says. I didn't make it up.
That's one of several means of transmission. Dispersal is
Well, discharge would be I think discharge is what you folks focus on. That's probably your
discharge,
strongest
dispersal.
argument.
And the net effect is, if we were to allow the grant of coverage, we are effectively writing the endorsement out of the policy. And the endorsement makes it so clear. Please read it carefully. This changes the policy. The policyholder's on notice that
Well, so that's the question. Would a reasonable business person read this to believe that he doesn't have business interruption coverage. And I would suggest to you that there would be some question about that.
A reasonable person who is charged with the responsibility of reading their policy as soon as they get it realizes that that Landmark has attached 8 unique forms to its policy, one of which speaks to pathogenic exclusions. And to the extent that there were any questions at the inception of the policy, that's the time to read it and raise those questions to determine what, if anything, they have any questions about. But when they read it, they accepted it, and they're raising it after the fact. Pathogen means what it says. Dispersal means what it says. When we apply these ordinary terms as applied by the dictionary, there's only one conclusion. Landmark changed its policy. It's endorsed the policy. The endorsement changes that main form. We're simply looking to have the Landmark apply or have its contract be applied the way the Glynn Court and so many other courts have applied that.
Well, why shouldn't we apply it the way the district court applied it in California?
I'll tell you why. Because which court? The Appellate.
Was it?
Or our Supreme Court.
Oh, well, okay, I'll tell you. Well, many of those courts, in fairness to counsel, many of those courts out in California got reversed through no fault of counsel, but, it was a very active jurisprudence. So a lot of the cases I would bring to the court's attention, many of them got reversed, especially out in California. So I would urge the court to take a look at my paperwork and take a look at that. In terms of the Getling case, that was the Supreme Court in Queens. And why that's different is, number one, I actually think that decision contains a mistake because the court refers to it as a coverage grant. It is not, it's an exclusion. But once again, you know what the court said in the Queens County Getling case? It said, you know what? The term pathogen is not defined, and because it's not defined, it must be ambiguous. But you know what? In doing that, the court respectfully did not apply the most basic rules of construction, which is where a term is undefined, you go to the dictionary, which is exactly what counsel and I both did. And the court doubled down and said, you know what? Whether it be dispersal, discharge, the fact of the matter is that pathogen wasn't defined. And you know what? If we were to go to Merriam-Webster, as we do here, and courts across the country have done it, it means what it says, which it's an organic material, and that's exactly what COVID-19 was. Now, addressing all the decisions which are not binding on you, why that's significant is, I'm not suggesting that you should follow those decisions and just follow the masses and do what they did. But what's important to note about those courts is that they didn't have any precedent. They were unconstrained by stare decisis. And yet each and every one of them, reading this exact same form, Landmark, applied it separately and individually, and each one of them found that the pathogen endorsement changed the policy and served to preclude all coverage for COVID-19. They all reached the same conclusion on their own without each other. That has to tell you that there are many courts interpreting this exact same Landmark endorsement reached the same conclusion, not a CGL pollution exclusion, this pathogen endorsement.
Thank you, counsel.
Thank you very much for your time.
You have AIG, sir?
Yes, may it please the court, Keith Moskowitz. I'm here on behalf of both AIG and also the respondent Everest. I intend to address 2 issues with the court. The first is the civil authority coverage, and the second, as the bench was referring, is the virus exclusion that exists in the AIG and the Everest policy. With respect to the civil authority coverage, the principle here, as a matter of contract construction, is straightforward. The civil authority coverage requires direct physical loss or damage.
Hasn't this been decided by our court already?
And it has been
Century
decided.
21 and consolidated, is there anything different in this case?
There is no difference. And indeed, this exact policy language, just to put a cherry on top of the argument, would be the U.S. Fourth Circuit Court of Appeals decision in the Golden Corral case, which looked at the exact same policy language, looked at the exact same argument that's made by the appellant in this case, rejected it, adopted the position of AIG and Everest, all of which on rules of contract construction that I would respectfully submit are fully in line with those applied by the Court of Appeals in Consolidated Restaurants, as well as this court in Century 21. So I think that's straightforward. Let me then turn, if there are no further questions on the civil authority, to the virus exclusion. So here, what I would respectfully submit on this question of traditional environmental pollution is that when first you look at the traditional environmental pollution cases, they all, including belt painting, hinge on one fundamental predicate issue, which is that the exclusions have broad terms like contaminants, irritants, etc. And you have a case that involves a particular causative agent that doesn't necessarily cleanly fit in to that. And so therefore the courts break and look at the exclusions and they say, well, this is going to be limited to traditional environmental pollution. The fundamental difference between each of those cases, including Belt, and the exclusion in the AIG and Everest policy is that here, the drafters and the parties specifically use the term virus. So we're not talking about trying to pigeonhole virus and say, well, is it an irritant? Is it a contaminant? The term that the parties agreed to in the contract.
But the overall, when I look at this provision, it strikes me, and what our courts have looked at it and said, this is really, it concerns pollution. So agreed, you do have virus, but doesn't that create an ambiguity when you look at the overall structure of the provision and then look at that isolated word virus?
Respectfully not, for two reasons. One that is general to the exclusion, the other specific to this contract. The first reason I would respectfully submit that's not correct is that the insurance policy is dealing with a host of risks. Indeed, this is an all-risk policy. Therefore, when the drafters are putting it together...
But this is a pollution contamination exclusion.
Absolutely, because with all risks, we might have traditional environmental pollution risks, but we also have other risks of which the drafters here, and by agreement, because the parties bound themselves, identified virus. And therefore, there's no reason that an exclusion which may otherwise deal with traditional environmental pollution, so if there was asbestos in a building and it created a loss, that might fall there. You might think, well, that's traditional environmental pollution.
So is a virus a material?
Well, that's not in our exclusion. Unlike the landmark exclusion here, that the term virus stands alone. And
but when I'm looking at the provision, it seems to say that contaminants, pollutants means any materials, and then you go down and it talks about viruses, right?
Well, so what I would suggest to you is by using the specific term virus, we have a very clear underwriting intent that virus is a virus. And there's obviously no dispute we're dealing with.
And then let me draw your attention to the rest of it. Then it starts to list Federal Water Pollution Control Act. It suggests at least to, or it could suggest to the reasonable business person that we're talking about a environmental pollution exclusion.
Sure. 2 points on that, then I want to come back to one last contract construction point. The first point is the last antecedent rule, which New York follows, and we've cited cases that looked at this exact exclusion in COVID, applied the last antecedent rule, and concluded that the reference to the various environmental laws is modifying only the last antecedent, which is hazardous substances. Virus stands alone, so that's the first response to that. The second response is the one I made on just this is a policy that deals with all risks.
Counsel, I guess the only question that comes to my mind with virus standing alone, if we read the paragraph before about how this virus is spread about, it actually doesn't even say spread about, right? It talks about release, discharge, escape, dispersal, like active things that need to happen. Not that it's a virus such as COVID, that it was there. I'm just trying to, I don't know how we read just virus by itself without actually reading the vehicle for transmission.
Yeah, no, and I agree with Your Honor on that point. You have to connect the virus to a means of transmission. So I'm not suggesting that discharge and dispersal are not read in conjunction with virus. They must be to apply the term. As Judge Rakoff...
So then if that follows, the belt painting case would be instructive where that was related, those particular words were related to environmental events.
And I think the fundamental difference between belt painting, I'm going to go to the point I keep signaling I want to get to because I do think it's important also to this question. If you look at the construction of the policy as a whole here, we have a policy that provides direct physical loss or damage. As Your Honor asked me the question at the outset, that's Century 21, that's consolidated restaurants. There's a special coverage. So what happened here is that the policy doesn't cover virus, but the parties got together and said, we're going to create a special coverage only for virus. And what makes it special is no direct physical loss or damage, but also because there's an exclusion. So when these parties contracted together, there was a meeting of the minds that the policy and its principal coverage wouldn't apply to virus. How do we know that? It has an exclusion.
Wait a second. Are you saying you don't get together with the insured and draft your policies. That's not how it works.
No, and that's a fair point, Your Honor. Let me rephrase my point.
Thank you.
That's a perfectly fair point. The policy that was presented to another sophisticated commercial entity, they had a broker, they reviewed it, they accepted it. We drafted it. The more important point is that the special coverage is bringing back in this very limited coverage for virus. Why? Because it's excluded, because it wasn't underwritten in the main policy form. And this reverse activation, which was expressly rejected in Century 21, if that were allowed, and I think the debate ends there, right? You don't even reach the exclusion, just to be clear. If the court applies consolidated restaurants in Century 21, there is no coverage. We don't reach the exclusion. So I respectfully submit it's academic. But if one was to reach the exclusion, it would only be because we got around consolidated restaurants in Century 21, somehow the policy reversed activated, and at that point the exclusion would apply because, again, the policy is not designed to cover virus except for that special coverage, which my client happened to pay.
Thank you, counsel.
Thank you.
Good afternoon, Your Honor. Robert Goodman, Mount Cotton Woolen and Greengrass for defendant respondent Star Surplus. With respect to Star Surplus, the coverage that the plaintiff seeks has been excluded. The plaintiff says that imminent loss, that in the civil authority coverage, imminent loss by a peril insured under the policy includes the contagious disease coverage, which is in the special time element clause. Even if you do get to that, which I think Mr. Moskowitz has shown that you don't, when you look at the endorsement 11 in the STAR policy, with respect to special time limit, it says limit excluded. There's nothing there. And not only that, the plaintiff, does the policy make it clear that the argument of the plaintiff is excluded, the plaintiff has admitted it. If you look at paragraph 81 of the complaint, it says STAR policy, special time element, limit excluded. If you look at footnote number 1 on page 5 of the plaintiff's brief, it says we're not seeking contagious disease coverage against STAR. So the whole position that the plaintiff is taking here is contrary to the plain language of the policy, and it's contrary to their own admissions. They have no business asking STAR for anything here. It's excluded, end of story. Thank you very much, if Your Honor doesn't have any questions.
Thank you, counsel. Rebuttal.
I'm ready when you're ready, Your Honor.
Okay. Go ahead, counsel.
We just say go, or?
Go ahead.
Thank you. Your Honor, I will try to be as brief as possible. Holistically, the court has said it time and again today, how do we review exclusions? How do we understand exclusions? They have to be clear, they have to be unmistakable, subject to no other interpretation. They have to apply in this case. And when we talk about contract construction, we must look at this through the eyes of a reasonable business person, of an average insured buying insurance. That's belt painting, that's VI techs, that's all of these cases.
Counsel, can you just address Landmark's argument that the endorsement negated the policy?
Yes. On page 5 of our brief, we cite a Court of Appeals case called Birnbaum. And I think Birnbaum's a really important case because it ties into these rules of construction where it says just simply saying we have an endorsement, you have a policy, therefore there's no coverage, that's not enough. It's got to be clear and unmistakable, and you should be identifying the provision. It should be crystal clear, as Starr has just argued. We said we don't attach to, in endorsement 11, we specifically reference this provision of the policy. That's the kind of specificity that's necessary. Otherwise, all of us are sitting here trying to figure out how these things connect. Is a contagious or infectious disease the same as a pathogenic material? Those are the questions that we should not be asking, and those are the questions we would not be asking.
Except the problem is, counsel, that it is. That's exactly what a pathogenic material. It's not like you're saying they could be two different things. Pathogenic, it looked up in both Black's and Merriam-Webster in every dictionary. is the same thing. It's not that
And
it
Your
can't-
Honor, we're
there's
not,
no ambiguity as to that term.
we are not debating the
So
term
where is the
pathogenic. We're talking about the
ambiguity?
term material. And we're saying that the term material is unclear, and in our view,
What
it
do you
should be something that builds something, that's capable of doing something. And the fact that we both refer to Webster's in Merriam-Webster's, in our opinion, their argument is, well, there are multiple dictionary definitions, and you should have looked at a different one. You looked at the wrong one. But our point there is that just shows that they could have used clearer language to establish this
What could have been
exclusion.
clear? This says exclusion of pathogenic or poisonous, biological or chemical materials. What is unclear about that?
And again, Your Honor, trying to understand what a pathogenic material is when you're buying this policy at the outset.
Well,
with
give
the
me one
benefit-
example of what other
We
things.
talked about a receptacle in our briefing. What if you actually kept virus materials on your property? What if you're a hospital system? What if you're a lab that's experimenting or using chemicals to construct manufacturing materials? There are a whole slew of uses and cases in which this could come up. So I apologize, Your Honor, I should have gotten to that faster. But I would also add, we still have a problem, as this court has noted, with seepage, with discharge, with dispersal. It's just not clear, and there was better language out there. And the counsel stated that the California cases have all been overturned. That's not true. The Segerstrom case is the case that we highlight significantly in our brief. And in that case, they specifically said when you have a grant of coverage paired with an exclusion, the fact that they mentioned contagious and infectious disease twice gives credence to the idea that their reasonable expectation was that they would be covered for contagious or infectious disease. Just trying to move quickly through the rest of these arguments, I appreciate the comments of counsel on the civil authority coverage, but it is not the same thing. And I think we get into this in great detail in our brief. Our policy has language that speaks to imminent loss. It doesn't exist in any other policy that's come before the court. And it's true that it did come up in the Golden Corral case. But the difference between our case and Golden Corral is in the orders. And the orders themselves speak to their imminence. Now, again, this is a motion to dismiss. So we have not had any factual development. We have not had a chance to speak to anyone, to collect documents, to see how these things were interpreted. But our argument is that the orders themselves are different. Century 21 is also a very different case because if you look at the text of our communicable disease coverage, it actually says that nothing herein shall conflict or reduce with coverage elsewhere in the policy, most notably interruption of civil or military authority. That's huge. The other thing that's really important there is it says notwithstanding no physical loss or damage, it extends the policy to provide coverage for communicable disease. So I think we've got a better hook there. And lastly, I just want to hit on something that Judge Singh pointed out in the virus exclusion. In the pollution exclusion, which is that it speaks to materials after their release. So again, going back to what I mentioned at the beginning of this rebuttal, when you think about rules of construction, was a reasonable policyholder on notice that they would not have had coverage in this particular instance? I think the answer is no, or at a minimum, it's ambiguous and unclear, and they should have used a clear virus exclusion if their intent was to exclude virus. Thank you very much.
Thank you, sir. Thank you all. Very interesting argument. Osari?
Good afternoon, Lisa Gokul-Singh of Gannon and Rosenfarb for Bradhurst Court Condominium and Bradhurst retail owners. Fortunately, going after an insurance coverage case makes a lot of my argument quite easy. We don't have to go to Merriam-Webster. We don't have to go to Black's Law Dictionary. We just have to look at the language within the lease. The language in the lease obligated the landlord to maintain and promptly make repairs and replacements to the structure, exterior, roof, ceiling tiles, and the floor of the building. And the word building is capitalized. Later in the agreement, it defines what the term building means. It refers to the gross floor area, and then it specifically says that that does not include loading areas or loading docks. The plaintiff's accident occurred on a loading dock. But it specifically occurred due to the instrumentality. But just with respect to the location of the accident, it was not something that the out-of-possession landlord had to maintain. And according to the affidavit that we submitted, they had never maintained it, they had never made repairs, they had never received complaints about it. But the lease is very clear. I think the lower court focused on the factual similarities in the Young versus Coffee Crescent case. But even when you read the Coffee Crescent case, it says that the lease language was what was controlling, and the lease language should have been controlling here.
So why do you believe that here there is no ambiguity with respect to whether or not the out-of-possession landlord has any obligations with respect to this dock, i.e. the dock is not part of the structure? I read your argument, but why don't you explain it a little better?
Again, well, because the definition of building specifically excludes the loading areas and loading dock. I mean, you can't be more specific to the area where the plaintiff was injured. And as a result, it expressly excludes that particular area from the definition of building. And as a result, they were not obligated under the lease to maintain it. And then, again, going back to the affidavit established that there was no course of conduct, there was no extra contractual obligation that was undertaken, and so they never breached their protection as being an out-of-possession landlord under the express terms of the lease.
I don't know if it's really an exclusion, but I guess that's left over from the last argument, of the reference of the loading dock, as you say, you know, from that the lease excluded the loading dock. Was that contained in the appropriate portion of the lease, or was that talking about something else and not about the areas that the landlord was obligated to maintain and repair?
I think so the maintenance provision is in paragraph or Article 12, but the definitions are in another portion of the lease. But
and that was the part of the lease that defined what the landlord was to provide in terms of square footage? And is that where it excludes the language, or is it someplace else?
It excludes it, you know, again, because it is a defined term, or if it's capitalized, and it's a defined term, you do have to search. It's not directly there. It doesn't say it in Article 12, oh, by the way, this is what building means. But if you read the lease overall, when you're trying to find the definitions, it is very clearly there that the area of the building does not include the loading docks, which is entirely within the purview of the Pathmark grocery store. As far as the other arguments, I will wait for rebuttal.
Wait for rebuttal. Counsel?
Good afternoon, Your Honors. If it please the court, Zahir Merchant for plaintiff respondent Carlos Irizarry.
Is building defined?
That's the issue, Your Honor. The building is not, the definition is at the end of the lease agreement. It's not.
What about your adversary's point that it's a defined term? And if it's a defined term, then we have to look at the definitional section to determine what it means.
Right, but our argument, Your Honor, is that at best that is ambiguous, as within the section where it speaks about Article 12.1 speaks about the landlord's responsibility to maintain. They specifically talk about the structure of the building and the exterior, the structure and the exterior of the premises, and they exclude doors, windows, and tenant signs and door frames. They do not exclude the dock or the dock plate. And once again, as Judge Schumacher pointed out as counsel pointed out in Young versus Crescent Coffee, Judge Schumacher pointed out that was almost exactly on point.
Well, was the lease language the same in that case? We don't really know. So
I have not read the lease.
Factually, I think it's similar.
Right. So the court said there is at least a question of fact with regards to whether a dock, not just the dock, but any bumpers, lifts on the dock, are part of the structure of a building, which would make it the landlord's responsibility to maintain. And I would rest on our brief unless the court has any other questions.
Thank you.
Thank you, Your Honor.
I would.
Counsel, what section of the lease do you say defines the term building so as to exclude the dock? So I want to take another look at that.
Sure. It's at record page 51, and it's section 1.3G.
Okay,
We also did argue in the alternative that if we were in possession, that we didn't have notice of the condition. Again, we submitted an affidavit indicating that there were no complaints and that we had never made any repairs with regard to the dock plate or the loading dock at all. The plaintiff did not raise an issue of fact as to that. Thank you.
Thank you. Thank you both. Law offices of Cyrus, Jubin. You may proceed, counsel.
Thank you. Good afternoon, Your Honors, and may it please the court. My name is Cyrus Jubin, representing the Appellant Law Office of Cyrus Jubin. The issue I want to focus on today is the nature of the DA data sheet and whether it constitutes attorney work product. The DA data sheet, as reflected by the sample data sheets in the record, I provided 2 sample data sheets.
Those data sheets that you provided, were those the result of a FOIL request, or are they come from a criminal case?
Though one was from a criminal case and one was from a Section 1983 lawsuit in which they were obtained through discovery. Those data sheet samples, I don't have the data sheet that's at issue here, but those data sheets can essentially be superimposed on top of each other as a boilerplate document in which various data fields are filled out by employees of the district attorney's office. There's nothing besides getting information from police documents.
So in this instance, the court performed an in-camera inspection and found that the data sheet was a work product. Are you saying that that's just flat wrong? I mean, we don't have the data sheets ourselves, so it's hard to judge it. So it's based on the arguments you both make and what the court said.
Indeed, Your Honor. And looking at the court's decision, unfortunately, there's zero guidance about what specifically the court thought was attorney work product.
Yeah, but I mean, so, right. So, but that is, and the court made clear that that it's not saying that these are always subject or are always subject to attorney work product, but the court looked at this particular one, and we have to assume that a judge in the trial court knows what attorney work product is, looked at it and said this contains it. So where are we, how could we possibly overturn that?
Well, I think it has
Wasn't making a blanket rule, we both agree. I mean, wasn't saying these are always exempt, right? But having looked at this one, the court said, I find that there is stuff here on that document that is attorney work product.
I respectfully submit the court was wrong.
Based on what? How, why? But why do you say that? You have no idea what was on it, right?
Right, and I say this with caution. I'm basing this on various clues I've gotten from the sample data sheets I presented in the record, as well as the arguments from counsel stating what the work product is that they believe was.
For example, the bail recommendation?
Exactly, the bail.
That would be something that would be said in open court at some point, right?
Precisely right, Your Honor. The bail recommendation and the order of protection request. Those are the 2 things that are indeed reflections of an attorney's legal training and experience. I concede that.
The judge, I mean, he tried to be very careful and limiting, and he did say that he concluded it was work attorney product because it references the mental impressions, the conclusions, opinions, or strategies of the assistant DA assigned to the case. So are you saying he was wrong, there was nothing on there, and he didn't see that?
Well, if the judge was referring to the bail application, the bail request, and the order of protection, that is work product. However, those are necessarily stated on the record at the arraignment. The whole purpose of putting those pieces of information in the data sheet is to communicate to the district attorney at the arraignment to ask for a certain amount of bail or an order of protection.
Are you sure that what's on that sheet always is what the attorney who's at the bail hearing recites? Couldn't it say, I think maybe you should do something between $1 and 10? I mean, I have no idea. Do you? You don't either. Here's my impression. You may or may not agree with me, right?
Well,
Would that be covered by attorney work product? I mean, attorney impressions?
Well, having seen the samples provided and having stood in literally over 1,000 arraignments, Your Honor, it is always communicated and is always stated on the record. I cannot, theoretically, is it possible? Yes. Has it ever happened in practice? No. The whole purpose.
You're saying that what's on that sheet and what the district attorney requests are never, or 100% of the time the same thing?
Absolutely. Absolutely. And I think the court can take judicial notice of the fact.
Okay.
Thank you, counsel.
Yes.
May it please the court, I'm Philip Tisney for the respondent.
Counsel, just to pick up on that thread, oftentimes, maybe at an arraignment where a district attorney is reading off a bail request, one might say that they would say, well, this is what's on the sheet. This is what has been said. So isn't it, we can kind of make that inference that the bail request that's written down on the sheet is the one that's stated in public on the open record, right?
I think you could make that inference if there was something in the record, like a transcript from the arraignment, that suggested that the recommendation in the data sheet was the recommendation that was conveyed at the arraignment. There are certainly circumstances, Justice Scarpula, where an arraignment or a bail request that is proposed by the people at arraignment is not what's on the data sheet. And it might be the case that an arraignment or a bail request that's made in the data sheet never gets to arraignment because the case never gets to arraignment.
The data sheet that was provided, one of two, the adversaries indicating came from the criminal case, so that it was turned over as discovery in that particular context. If it was turned over as discovery in that particular context, why wouldn't it be necessarily needed to be disclosed as a FOIL request?
Well, I think if it was turned over in discovery, in criminal discovery, we wouldn't be here because either they wouldn't be asking for it or we wouldn't be withholding it. The reason that...
Well, no, I guess my point is that clearly he has one in those, and the representation is that it came out of a criminal case. So it has been turned over before. It's not as if these data worksheets would have never been turned over, otherwise we wouldn't have looked at two of them.
The disclosure of information in criminal discovery isn't a blanket waiver of the attorney work product exemption, certainly not in FOIL context. And even if there was some question as to whether the bail recommendation itself had been waived or the privilege had been waived with respect to that piece of information, there is still other information that's contained in the data sheet that is properly subject to attorney work privilege. And as this court's decisions and the Court of Appeals decisions make clear, there is no redaction remedy that is provided by FOIL. You can't say, okay, well, you get this piece of the data sheet, but not this piece. And if there's any piece of it that is protected by privileged information, then the whole data sheet has to be withheld. There's no question that an attorney's review of the facts in a case and decision that these facts are important, these ones aren't, these are the ones you should emphasize when you go in to make your bail recommendation. There's no question that that is precisely the kind of...
I guess I'm just wondering, if these things are discoverable in the criminal case, and it would be subject to redaction at that point, certain things would be redacted, is this some kind of distinction without a difference? I mean, why wouldn't it be then be able to be disclosed under FOIL? You can get it in one context, but unless your criminal case moves to a certain point, then you're not going to get it. But you can still get it in a criminal case. There's nothing saying that you can't get it. In fact, these things are turned over.
Statutes, Your Honor.
I understand there are two different statutes. I understand that. I mean, obviously, that's why we're here, right? I get that. But I'm just wondering, what is the reasoning behind the fact you're saying, well, you can't redact certain things underneath the FOIL request, and that's why now we don't have to turn over this document. But in another context, redaction's clearly acceptable, and these documents are turned over.
It's because the statutes are different, Your Honor. FOIL doesn't provide that mechanism here. The Court of Appeals has said that, Your Honor. This court has said that. Civil discovery in federal civil rights litigation Different statute, different requirements, different disclosure mandates. Criminal discovery, obviously, different disclosure mandates. But FOIL itself does not provide for a redaction remedy. The Court of Appeals could not have been more clear on that point in matter of NYCLU not that long ago. And this court, too, in matter of, I think it was Stengel.
Right, but wasn't that in the context of like disciplinary hearings and things of that nature? That's not what we're talking about here.
This court's decision in matter of Stengel was with respect to a DA data sheet, exactly the same type of data sheet that is at issue here. And the court said that given the Court of Appeals decision in matter of NYCLU, there is no redaction remedy available under FOIL, setting aside whatever redaction remedy might be available under different statutes governing different processes.
Thank you, counsel.
I would just make.
Well, counsel, let me just ask this question before you make your point. I mean, it's two different statutes. How do we get around that? With the FOIL statute clearly says you can't redact things. How do we get around that?
Well, I believe the way to view this document, and I think there's some overlap in our positions here, is that this document is best viewed as an intra-agency communication, which does provide a redaction remedy. I mean, this is a classic intra-agency communication. I would, without having seen it, I would submit based on what I've previously seen. This is mostly data, hence the term data sheet. And the intra-agency exemption does have a redaction remedy, as conceded by respondents, that is applicable to intra-agency communications. And I think this is a intra-agency communication par excellence of one attorney communicating to another attorney within the same agency, and there is a redaction remedy. There's no dispute about that. The Court of Appeals has held that there is a redaction remedy for intra-agency communications, and that's how I believe this document should be properly viewed.
But not for these data sheets, right? The Court of Appeals has said that there isn't a remedy for redaction for these.
The Court of Appeals actually hasn't heard a case regarding DA data sheets specifically. It's held in another context. It looked at police documents called DD5s, which are also information-rich documents, and there the NYPD tried to withhold the documents in their entirety. The Court of Appeals looked at it and found that it was an intra-agency communication and imposed a redaction remedy. So the Court of Appeals has never actually looked at the data sheet issue, but it has looked at other documents and imposed redaction subject to the intra-agency exemption.
Thank you, counsel. Thank you both.
Thank you.
Abus-Miaka versus Brisk.
Good afternoon. May it please the court. Thomas Farinello for the appellants. This is a case in which the parties were subject to a commercial lease. Over the course of 10 years, the plaintiffs in this matter were tenants to the landlord defendants. There was a security deposit that was tendered in the amount of approximately $36,000. So
let's go to the notice requirement. Let's just get to the, you don't have much time, so let's get to the heart of the case. Is there a notice requirement here to seek the additional rent, or does the lease, is there a carve out in the lease?
Under the lease, there's a default provision in the event that the tenant is in default. There were certain things that are to be done pursuant to the lease under Section 17 of the default provision, which is
But that's for things default for things other than payment of rent or additional rent, right?
Well, no, it was for additional rent or billing, or it says bills and notices as well. So in the instant case, the landlord didn't ask for the taxes and the water bills until 10 years after.
Is the argument they're waived?
Well, to the extent that yes, they waived because over the course of conduct over a
Isn't there
decade.
no waiver provision in this lease, like every single
Of course
lease
there
I've
is,
ever
but
read in New York City?
But the courts have held that they in these types of instances, they look to the course of conduct. The lease term had actually ended. And so there was also under the lease provision, the landlord was required to give a specific notice as to how, if in fact he was not going to return the security deposit, why he wasn't going to return it, and basically detail the reasons why, which was never done. But more importantly, the lower court did side with the appellant in the sense that they awarded the $36,000 back, but they never awarded the interest for the time it should have been held and set aside. And then they should have issued, the lower court should have issued a separate judgment assessing statutory interest based upon the general obligations law, because the landlord acknowledged that he did not hold the security deposit in a segregated account, and he provided no documentation as to where the security deposit was. So essentially, pursuant to the general obligations law, it shouldn't have been used as an offset. It should have been entered as a separate judgment with statutory interest, and also the interest was never considered from the time that the monies were deposited way back in 2006.
If we were to disagree with your position and find that additional rent, the landlord can seek additional rent in this case, and no notice is required, what's the period for which additional rent can be sought? In other words, is there an issue with statute of limitations here?
I think to a certain extent. I mean, and not only that, but to the point, there was a lease renewal which required the tenant to be current. And so the courts have held that when you have a lease renewal and there's an acknowledgement and an understanding, and it's conceded that the landlord knew, but there was never any demand for this additional rent, it could constitute a waiver. But in terms,
Or at least you can't go back, well, at least you can't go back till 2013, right? There's a 6-year statute of limitations.
I agree.
So at a minimum, you have to go back to this, you can only go back 6 years, not till 2013.
Yeah, yes, I agree with that.
Thank you.
Thank you.
Good afternoon, may it please the court. Mark Krantz for the respondent, the landlord here. Your Honor, if I can just jump in right away to the issues that are being
Yes, but let me just, you don't dispute that you owe the statutory interest, right? Because you commingled.
No, we have no issue with that.
Okay, so.
No, that's the return of the security.
Right, the security
And
deposit,
actually, I
right?
had one more question with respect to that. Excuse me, is do you agree with counsel that that has to be in the form of a separate judgment with interest, or you think it can be done as an offset, if we were to agree with your position?
No, I think it can be done as an offset, and it is offset. That's the way the lower court.
No, I understand that, but that's not what your adversary is arguing.
Right, I don't quite understand my adversary's argument going into the interest on that, saying that the court should have awarded them interest on that amount of money.
Well, right, wouldn't they be entitled to interest? You breached the contract, wouldn't they be entitled to interest, just like you would be entitled to interest?
Right, Your Honor, you're correct, but by offsetting it, they get the benefit of that interest.
No, they don't, because the number, you start with the end number and then you offset it. And your number is just a straight offset of the security deposit amount. That's not the correct offset.
No, but because we're not getting interest on the amount that.
That money has nothing to do with the amount you're owed under the lease. That's on their counterclaim. That is on their counterclaim. It has to be offset in a different way. The court has to figure out the counterclaim amount plus the interest and then offset it, and which did not happen here. Anyway.
I'm confused on that because I think mathematically it comes out the same way, but okay.
I don't.
No, it doesn't.
Right,
Because
but that's
if there's a breach, if you breach the lease and you commingle the security deposit, they're entitled to, I think it was $36,000 or whatever it is, plus interest, right?
Plus statutory interest.
Yes, okay.
Going back to the time of the breach, that's what we're referring to.
Okay, and on the monies that were awarded to my client, we also got interest on that, but we netted off the $36,000 security, so we reduced our statutory interest on that amount, so.
But the court didn't take into account the statutory interest. That's the problem. Okay.
Now, what about the statute of limitations?
Okay, statute of limitations, Your Honor, they didn't raise this in opposition to the court below.
It's a legal issue. Why can't it be raised for the first time here?
Yes, Your Honor. I addressed that in my brief. When we have an argument to the court below on that, and one of them is, for example, one of the exceptions to the statute of limitations, they continue making payments. So there are exceptions. We didn't have that opportunity to address that in the court below. Those circumstances cannot be raised in the appellate court. But may I add, yes?
Can I just, what counsel argues that when they renewed the lease and they were current, that would have been the time to raise these additional payments, the taxes, the water, that would have been the time. And the fact that they renewed their lease is an indication that these monies were waived.
Okay, Your Honor, you're going back to the waiver issue that they were saying before. There is a clear non-waiver clause in this lease that specifically talks about if we don't accept additional rent, it's not waived. That was the agreement in the lease, the judge said before, very standard language in commercial leases. This case law, and I parse it all in my brief, discusses their cases. The court below cited to cases, court below cited to Goldston and Square Block, which counsel did not even discuss, where it's very clear. If money is owed, it's owed. It's not waived. There are certain rights that can be waived and are waived. Sometimes if someone does not, if someone's late on a lease payment, for example, can you terminate it 8 or 10 years later? But that's not the situation here. Situation here is where the money's owed. They agree the money's owed. There's no question about it. They agree the money's not paid. There's no question about how much.
When did you first assert the breach?
When did we first assert the breach?
Right.
Well, the landlord verbally told it to the tenant, but before this action was started, Your Honor, there was
When did you put in the record that you asserted the breach of the water and the?
Okay, before this action was started, there was a demand that was sent to the tenant, and it's in the record, Your Honor.
Which was when?
Which was pretty soon before this action was started.
And so you're saying that you made your first demand in 2017?
First written demand, Your Honor.
Where is that in the record?
Where is it in the record?
Yeah, where's your demand for water and sewer charges? Where's your first demand for water and sewer charges in the record?
Okay. It was by way of an email. It's the record 365 and 366, Your Honor. But I will make the point, Your Honor, that we're not required to make a demand. But yes, I
For
understand.
statute of limitations purposes, right? Yes, you are. So we're going to figure out, because you can't go back 30 years. We all agree, or maybe you don't agree, but I think that's pretty straightforward.
Okay, Your Honor, just go back to my point below that they did not raise statute of limitations in the court.
Did they assert it as a defense to your
An
counterclaim?
affirmative defense, yes.
Yeah,
They did
so
not
they
raise
raised it.
Well, they have to raise it in opposition to a motion of summary judgment. They were completely silent on that point.
Okay.
And even so, Your Honor, I would just add, there's only a very short time frame that's beyond the statute of limitations. Okay. I just want to discuss one more quick. Yep.
We're done.
Okay, thank you, Your Honor. Appreciate it.
Okay, sir. 2 minutes.
Thank you. Another issue that...
No. I want you to address the issue raised by Judge Scarpula. When did you first get a demand for rent, additional rent?
The first time I ever saw a written demand was in the reply opposition to counsel's papers. We had made a post-deposition discovery request.
Can't be right. They counterclaimed for rent, right?
Right.
So when was that?
I never saw a written demand.
You never saw, wait, you didn't get a counterclaim? You didn't read the counterclaim?
Oh, the counterclaim.
Oh, isn't that a demand?
Yeah, that was a demand back in 2000.
When was that? What was the date of that?
The date the complaint was filed.
2019, no, counterclaim.
Yes.
2019, I think, is that right? Go ahead.
But with regard to the notice, at the deposition, the principal of the defendant testified that he never sent any notice for demand, and you'll see on my brief in page 27 that Mr. Brisk, the defendant, responded and admitted he never sent any written notices and demanding the real estate taxes or payments, and then this email showed up in a brief. There are document requests made. There are objections made because documents were never turned over with regards to the real estate taxes, certain bank account information. So there was a lot that went on here that I think the lower court considered that probably it shouldn't have considered.
Thank you. Thank you both. Sybil versus Arola.
May it please the court, Your Honor, Your Honors, Robert Garson on behalf of Sybil and et al., the appellants. There is not one justice sitting in this court that would have acted in the way that the Scola firm did. There is not one justice in this court that would have taken $500,000.
Counsel, can we get to the argument, please?
But, Your Honor, this is at the core of the argument. That would have taken $500,000 from a client.
You can leave us out of it. Just make your argument.
Well, Your Honor, or Your Honor Singh, if one looks at page 82 of the record, when one of one's co-counsel states, "What do you think about Rick's point on withdrawal? Seems pretty ballsy and not necessarily likely to succeed. Theory is that Rowan hires us to advance the contract claims, not to defend the fraud claim. He may also have some criminal exposure, not our area of expertise." Unfortunately, Mr. Bennett, I believe 8 days after that point, dies, and he passes away. At the memorial service, Mr. Brooks tells Mr. Sybil, "Unfortunately, we're going to have to withdraw from your case $500,000 later because it's impractical." We bring this matter before the court, and at the same time, we're not permitted to do any disclosure in relation to this case. There's summary judgment without a shred of invoices having been sent to Mr. Sybil, not one.
I'm sorry, go ahead.
Well, I mean, are you suggesting that they didn't do any work? I mean, the retainer agreement said that there was a cap, I believe, of $500,000 up until a certain point. And you paid that, didn't you? Didn't you pay that?
Mr. Sybil paid that up front. He was made to pay $250,000 up front, then $50,000 per month, so they could have assurance.
But as he suggests, they sent you account, they sent you invoices, and you retained them, and you never complained about them, and they represented you for a while, and they did work, but then things happened where they felt that there was a problem, they needed to withdraw. I don't get what the issue, what's the problem here?
Well, Your Honor, there are many problems that go on here. Let's just say, Your Honor Kaepernick, you're right, that they did all the work properly. They billed $500,000, and there is evidence in the record, which there isn't, that they properly invoiced that along the way.
Wait a minute. Let me just stop you for 1 second. I want to understand just one simple point.
Yes.
Are you claiming that you didn't get invoices, or are you claiming that you objected to the invoices you got saying that the work was insufficient, or however you objected?
There are no invoices in the record.
Does your client dispute getting invoices?
My client disputes getting regular invoices. Yes, he does. My client disputes the fact that the work was properly done. My client had to go away and spend $700,000 to get alternative counsel. My client disputes that the only evidence we have on the record...
Your client disputes it now. At the time the invoices were sent, does your client say that when he got an invoice, he said you didn't do this work?
We don't know when they're saying that those were...
You know, your client knows exactly what he got. Did he say in any way, shape, or form, when I got an invoice, I disputed it at the time?
Your Honor, no, because that's not in... But, Your Honor, we're not in the record in relation to that. They still, regardless of... Because this is...
That's an affidavit that your client could have drafted and said, yes, I did get an invoice on this date, and yes, I did object to it, right?
Your Honor, yes, but that
did
doesn't...
your client do that?
That doesn't alleviate their
I'm just asking
responsibility under
first whether
Stone
your
versus
client did
Goodson.
that. I just want to first say, did your
My
client do
client
that?
never drafted an affidavit to say, I objected to those invoices at that time.
Okay.
Right? However, under Stone versus Goodson, which we point to at page 30 of the initial brief, that does not alleviate the responsibility upon the plaintiffs or the defendants in that case to bring forth admissible evidence such that a court can say that this sustains summary judgment. Their affidavit is not good enough. Where is the one invoice that has been put into the record by the Scola firm? Not one.
Prior to getting new counsel, was there any request for a refund of fees?
Prior to getting new counsel, no. Mr. Seibel at that point was scrambling. He was told, sorry, we're withdrawing from this case. There is also at page 302 we have of the record, there is opposing counsel from Caesars writes to Mr. Brooks and say, you've told me constantly you want away from this case. You want out of this case. He's telling opposing counsel that in a case in which he's representing. Respectfully, Your Honor, I practice in 4 jurisdictions around the world. This is scandalous. I've never seen practices like this where somebody's treated like an ATM. A client is treated like an ATM. They are told we're going to take you to a certain point in a case, and then only after that $500,000 is billed that the law firm says, oh, sorry. Awfully sorry, it's impractical for us to continue in these circumstances. Let's take this to the nth point and the nth degree for the court. Let's say the Scola firm billed everything properly. Let's say they billed everything properly. However, their reasons for withdrawal were improper.
Well, was your client, getting to the reasons for withdrawal, was your client, was he truthful?
100%, yes. He states in his affidavit, I was truthful. There is not one email produced by the Scola firm that says, excuse me, Mr. Seibel, you've not been truthful. Excuse me, Mr. Seibel, you've not paid your bills.
What about with respect to the kickback? What was his explanation with respect to the kickback with the vendors?
He says that he stated that he had the kickback, that he was entitled to the kickback, and that it was lawful.
And in fact, what did the Nevada State Court do?
But the Nevada State Court found that later on, but you can't then say, let me take that differently, Your Honor. Let's say the Nevada State Court would have said that was entirely lawful. Would that then have made the Scola firm's
wasn't there other
actions unlawful?
Wasn't there other issues? There was a prenuptial agreement that wasn't disclosed that might have alluded to something.
Correct. And Mr. Seibel states that he never told the Scola firm not to disclose that. He says it quite clearly, page 266 of the record of his affidavit. There is not one email produced by the Scola firm saying, hold on, Mr. Seibel, you told us not to withdraw, not to disclose
In the
this
retainer
affidavit.
agreement, did the law firm retain the right at their sole discretion? I mean, that was something that was agreed to, that they could no longer represent, they could agree to no longer represent him if they found him unsuitable, if he wasn't candid, things of that nature.
Sole discretion actually is then tempered by impracticality, etc. But there's nothing in the record other than Mr. Brooks's affidavit. There's nothing contemporaneous at the time saying, Mr. Seibel, you're not being truthful with us.
Well, but they say that if they determine in their sole discretion that continuing services would be unethical, impractical, improper, otherwise inappropriate. And they put in affidavits which talk about the reasons that they felt that their continued representation would be all those things.
But Your Honor, that's ex post facto. The only evidence we have at the time, is Mr. Bennett saying, the theory is that we withdraw. That seems pretty ballsy. That's unlikely to succeed. Nowhere is there a response email from Mr. Brooks and Mr. Scola going, hold on, Mr. Bennett. We told you he lied to us. We told you he's not paid his expenses. We told you this. We just don't have it because we've never been allowed to do any discovery.
Why would that
in this
matter?
case.
If it's in their sole discretion, why would that matter at all?
Because it still has to be proper and ethical. We as lawyers...
You don't have to. It's in my sole discretion. If I am afraid that I cannot represent you, I get to go. That's what it says.
But not afraid that I can't represent you. It's impractical to represent you.
If
Or
in
that
my
you-
sole discretion, if I decide that, and there's...
But that cannot be applied arbitrarily. especially when it comes to sole discretion does not mean I can act unlawfully, I can act unethically. It does not give you blanket absolution to trample over the rules of professional conduct. Sole discretion still has to be applied properly and reasonably through the lens of good faith and fair dealing. It doesn't displace that, Your Honor.
Thank you, counsel.
Good afternoon. May it please the court. Daniel J. Brooks for the respondent. Let me start with this accusation that the reasons for
Can you
our...
move the mic a little bit closer to Mr.
Sorry.
Thank you.
Let me start with this accusation that the reasons we gave for needing to discontinue our representation, he says ex post facto, I think he means post hoc rationalizations fabricated by us in 2023 when we were sued, 3 years after we withdrew. I'd like to just read, because this is easily dispelled, from paragraph 22 of my affidavit, my moving affidavit. Taken in the aggregate or even separately, the impracticability of continuing the representation due to Steve Bennett's passing and Siebel's failure to pay key vendors and expert witnesses, semicolon, the misrepresentations and omissions of material fact which breach Siebel's duty to be truthful and place SCS, that's us, in the ethical predicament of being expected to present.
Counsel, you're reading from an affidavit. What your adversary is arguing, at least how I understand his argument, is affidavits say what they say, but where's the proof in the pudding? Where's the proof with respect to, for example, the invoices, that kind of stuff?
The affidavit says all of these reasons were communicated to Mr. Siebel in early January. The affidavit swears that at a meeting.
Right, but he's saying that there's no email, there's no.
There was a meeting.
I guess it would be email, text message, I don't know.
My affidavit and Mr. Scorolla's affidavit says that all these reasons were provided to Mr. Siebel in early January 2020, and that he then agreed. We said we either will have to move to withdraw, this isn't Mr. Scorolla's affidavit, or you'll have to find replacement counsel, and he agreed to. This is a sworn affidavit. He replied to this affidavit. He didn't deny that there was a meeting in early January 2020. He didn't deny that all these reasons were stated to him as reasons for us needing to withdraw. It's even worse than that. He denied one of them. He said, "You never told me you were going to withdraw because I didn't reimburse you for your expenses." He says that in his affidavit. He does not deny the meeting or that all these other reasons were given.
In the affidavit that he put in, did he deny receiving invoices?
No, that's the other thing.
Yeah.
I want to get to that. I have it here.
I just want to know, is there anything, you put in an affidavit that said we invoiced him?
Right.
We invoiced
And that they
him.
never they never
objected, but
objected to
it's
them.
worse than that, Your Honor. If you look at page 269 of the record, paragraph 40 of Mr. Siebel's affidavit, I'll read it. It's three lines. To the extent it tried to do so, defendant, that's us, was not authorized to bill the plaintiffs in excess of the $500,000 cap based upon the procedural posture of the case, namely the fact that neither discovery nor a motion for summary judgment had been prepared. That is not a denial, that is an admission, coupled with an erroneous statement that we were not authorized to bill over $500,000. That is not correct. There was a cap. We were specifically authorized, a specific agreement, paragraph 7B of the retainer agreement specifically contemplates that we might bill in excess of $500,000 because there was a potential success fee if we were successful at the end of the case, and that would be based on the difference between our discounted rates and our normal rates times the hour.
Yes, I just want to make sure that there is no denial that at the time of the invoices and the amount paid, that the work was done, it was invoiced as you went along, and at the time it was invoiced, there was no complaint.
There was no complaint about any of the bills. There's no denial. The bills exceeded $500,000. I swore to that. That's not hearsay. I was the only lawyer working on the case the last. I know how much we billed. They put in a reply. They could have said, oh, no, you didn't bill $500,000. You only billed $383,000. Guess what we would have done in our reply papers then?
You would
put in the bills.
invoices.
Yes.
I hope.
So it's not a question of hearsay, as they say. It's a question of the best evidence rule. The best evidence of the bills is the bills. But I swore under oath that we billed over $500,000. They didn't deny it. If they had denied it, we could have had a chance in reply to show that that was true. So it's the best evidence rule, not hearsay. And the best evidence is only required to be produced when there's a dispute. Can I just address a couple of these other things that were said? He never disputed the invoices. There's waiver. It's undisputed that there's waiver here. He says the waiver is only, you can't waive a claim like this by signing a substitution of counsel, and that's all he did. That's not true. This is what he did that constitutes waiver, as Justice Schechter found. He never, okay, first of all, he agreed to find new counsel. As Justice Schechter said, he facilitated the obtaining of new counsel. He spent 3 months doing it, finally did it. He never complained. He never said, and this is what, there's a colloquy with Justice Schechter. She said, you never said, I paid you, you can't go. Where does it say that in your affidavit, Mr. Siebel? Mr. Garson said, Your Honor, that would be an elevating form over substance. Page 26 of the record. That's not correct. This is summary judgment. Material facts are produced in admissible form. You have to deny them. If you don't deny them, you can't just say, oh, that would be form over substance. There's no denial. He never said, I paid you, you can't go. He said, I'm going to get lawyers for you. To replace you, I mean.
Thank you, counsel.
Can I just say one other thing about?
Last point.
Sorry?
Last point. Go ahead, make it.
On page 138, I'm sorry, I couldn't hear what you said.
Proceed.
Okay. On page 138, he says he was forced and pressured into finding new counsel. And he cites an email exchange that's on page 138 of the record. The main problem with that email exchange is he agreed to get new counsel in early January 2020. This email exchange happens almost a month later, January 27th, 2020. I had obtained a 30-day standstill from Caesar's lawyers when Steve Bennett passed away. He agreed to get a new lawyers. I see on January 27th, and it's all in here, that the standstill is starting to expire. And I'm just being responsible and saying, you know, by the way, the 30 days are almost up. Have you gotten the lawyers that you said you were going to get? And he says, no, we met with them. It's going to be a problem. We still want to, we're going to get, not in a time frame that you or we would like. So this is not somebody being forced or pressured a month after you'd already agreed to do it. It's a lawyer being responsible. And finally, last point, Your Honor, I promise. The email from Steve Bennett. The point is that when the kickbacks finally came out, we didn't know about them. He then lied to us and said, oh, Caesars knows about it and they're fine with it and it's a normal marketing strategy, which turns out not to be true. The Nevada court has ruled that that's not, the opposite is true. But Caesars made a motion to amend, to add new claims for tortious interference with contract, unjust enrichment, fraudulent concealment, and something else, serious counterclaims against Mr. Siebel, which were not within the contemplation of what we had agreed to do. And that's what the point of the email is. He's talking about an amendment motion. That was Caesar's motion to amend their complaint to allege serious wrongdoing and fraud on the part of Mr. Siebel, which the Nevada court upheld.
Counsel, thank you.
Couple of quick points for the court. Number one, the best evidence rule is not we don't have to supply initial evidence sufficient to get over summary judgment.
Well, let's just assume for argument's sake, they make out a prima facie case saying invoices were sent to your client and there was never an objection. What was your client's response in an affidavit?
Well, first and foremost, there wasn't a response to an affidavit. They should have put those invoices into the record.
You're saying there's no prima facie case made out, but what I'm asking you is, let's assume for argument's sake there's a prima facie. What was your client's response?
On the record, to them at the time? Is that your honest question? I'm sorry, maybe I'm being
back
silly.
and say, well, it wasn't billed correctly, and here are certain bills to prove it, or was there anything else?
Oh, yeah, Mr. Seabell did say that he felt, and he says it within his affidavit on page 266.
Did he object? Did he
wa-
say, I objected to the invoices? Because the issue is whether or not there was an account stated. That's what we're getting at. So, and in a way, you dispute an account stated is to say that you make timely objections.
Correct, because we have not seen...
Did you, in this case, or did your client make in his affidavit say that he made a timely objection?
No, he did not say that as to a timely objection. However, there is not, as Your Honor has already recognized, there's not the underlying, it says, the Stone case says it. In order to get account stated, you need to provide the accounts. You need to provide the details of who, what, when, why that was sent. And we don't have any of that here. What Mr. Brooks respectfully has said is, I've said it in a sworn affidavit. And that should be good enough for this court. But Mr. Seabell has also said something in a sworn affidavit. That's a credibility determination, which we now need to drag back to the courts and have disclosure around why was Mr. Bennett saying that Rick Scarola's theory was ballsy and not likely to succeed? Why was he saying that at that point? And just on the point of the best evidence rule, the best evidence rule is when the original doesn't exist, you can then put in a copy. The best evidence rule is not only when they raise something do I then have to make out my prima facie case. That's just wrong as a matter of hornbook.
Thank you, counsel. Thank you. Thank you. I thank you, and thank you both. People versus Wells. You may proceed, counsel.
Good afternoon, Your Honors. Ronald Zapata with the Office of Appellate Defender for Mr. Wells. Mr. Wells's request to proceed pro se before Justice Jill Convisor should have been granted when he made a voluntary knowing.
Did he make an unequivocal request to proceed pro se?
Yes, he did make an unequivocal request, and number one, this court is limited to only the reasons why this court denied the request anyway, and the court never said that it was not unequivocal, and therefore this court can only review what the judge's rulings were.
Didn't he say, for example, at the eve of trial, that he wanted to represent himself unless he could be heard for 5 minutes? Does that suggest to you a equivocal or unequivocal request to proceed pro se?
Well, but before we get to that, you're talking about the pro se colloquy before Justice Daniel Convisor. I'm talking about the pro se.
Well, I want you to focus on what I'm talking about.
I'm sorry?
Focus on my question.
Okay, regarding the colloquy regarding Justice Daniel Convisor,
Yeah.
I am not challenging the colloquy there. I'm only challenging the colloquy regarding Justice Jill Convisor, and therefore it's irrelevant to my argument here.
She had a discussion. She explained to him that, you know, it's sometimes a bad idea, which I think most of the judges do, for you to try a case by yourself. But she indicated that she would reconsider this, go back, think about it some more, and we'll reconsider it. And for a year or two, I don't think he ever brought it up.
Well, the problem with that is because once he filed Article 78, Justice Jill Convisor refused to take any applications regarding it. So once...
Well, you know, you're forgetting the fact, I mean, you're not really forgetting, but in 2015, I was on the panel, reversed the first situation because he had not been allowed to go pro se. So, I mean, I think obviously Judge Jill Convisor was aware of that. And I mean, now he's going again saying, I want to go pro se. I mean, that's why we reversed it the last time. I mean, it can't go on like this forever.
Well, yeah, and the problem is if they messed up the colloquy one time, it doesn't mean they can't mess it up the other time. And here's the problem here.
Didn't he make statements to the fact that he would proceed pro se if he had the help of an attorney?
Yes, Your Honor. You have to look at this in context of his pro se representations in the past. So he represented himself in 1992 in a trial. He represented himself in the suppression hearing before the remand here, and in the related Bronx case, he represented himself in a suppression hearing. And in all three of those cases, he had standby/legal advisor to help him. And obviously, he needed that help to, for instance, subpoena people. He can't do that by himself at Rikers. And so his understanding is that he's provided a legal advisor. And because this isn't preserved, if the court had said, okay, this is unequivocal because you're saying you want an advisor, he could have said, okay, well, if that's the case, then I don't want an advisor. That's why we have that preservation rule for the prosecution. And that's like precisely why, for instance, in People v. Schoolfield, this court stated, okay, the prosecution presented a new theory for why a pro se request was also denied. And the court said, no, you can't do any new arguments here because you didn't present that.
What is the construct of this hybrid pro se representation that should have been afforded him?
What is the construct?
Like, what would the vision be? If you said that he should have been allowed to go pro se, he could have done this with an advisor.
Yeah.
That it wasn't a hybrid.
Yeah. So in the past, he's basically had an advisor to talk to him about procedural matters and to, for instance, serve subpoenas to have witnesses be provided, and in the suppression hearings, which was what happened in this case prior to the remand and such. So that's what I'm talking about. But in terms of like if this is a knowing, voluntary, and intelligent waiver, like everything in the colloquy shows this is knowing, voluntary, and intelligent. And in terms of any kind of unequivocality, it's not preserved. And if this was a problem, then the court should have brought it up. The prosecution should have brought it up. The Court of Appeals and this court has stated that if it's not preserved, if it's not brought up, then this court can affirm on that kind of basis. And so, are there any questions regarding the pro se colloquy? If not, I could move on to the Sandoval issue, unless anyone has any questions about the multitude of issues I've raised. No? Okay. So regarding the Sandoval issue, the lower court committed further reversal error when it modified its Sandoval ruling to permit cross-examination on Mr. Wells' similar prior robbery convictions. Mr. Wells did not open the door to the convictions since he never testified about his 1992 conviction in New York or anything that was contrary to that conviction.
But didn't he answer a question that was asked to him about, did you ever have a gun? He says, oh, no, I don't like guns. I never had a gun.
Yes, Your Honor. And under People v. Fardan, like the precluded evidence has to refute the testimony that it gives. And the prior conviction was for possession of what appeared to be a gun, not of a gun. And therefore, that does not refute that evidence. And therefore, as the court stated incorrectly, the court said the reason I'm putting this in is because it's relevant to that. And Fardan specifically says just because something is relevant doesn't mean that it comes in. And therefore, because it did not refute it, that was an improper basis to allow that evidence to come in. And I shall, I guess, save everything else for rebuttal.
Make arguments on rebuttal. You may proceed.
Good afternoon, Your Honors, and may it please the court. Julia Gorski for the people. The reason Jill Convisor did not make any express findings about defendant's pro se application on the record was because she did not outright deny it. She adjourned the matter for further proceedings once defendant filed the motions relating to the slew of issues he had raised during the colloquy. And the problem had nothing to do with defendant's ability to correctly answer questions about a trial, how a trial is conducted. The issue was with defendant's statements, quote, whether it's by you or the appellate division, this case will not proceed to trial. I'm going to litigate this case to a dead end. This will never make it to trial. He was going to, quote, destroy this case by motion practice. All of those statements indicated that his primary intention here was to engage in disruptive conduct to delay the proceeding of his case. It is also worth noting that defendant bragged that he had successfully delayed the case so far by going pro se, appealing the court's decision to let him do so, and obtaining a reversal. In response to that, Jill Convisor said, oh, I see. What you're trying to do here is go pro se, so if there's a conviction, you can do the same thing all over again. Regarding defendant's request for hybrid representation, he was not seeking a legal advisor, and we know this because he kept saying that he could try the case with the help of his attorney, and then proceeded to indicate that he could farm out the parts of a trial that he didn't want to do. And further confirming that is that
For example, he wanted to cross-examine the witnesses but not pick the jury, things
That's
like that,
correct.
right?
And he confirmed that before Daniel Convisor a few years later, because he said, I only want to cross-examine the police witnesses, and when Convisor asked, you want your attorney to do everything else, he said yes. So for all those reasons, the judge had valid concern to not grant defendant's request at that time, and for those reasons, this court should affirm that decision. Turning to the Sandoval issue, defendant's constitutional challenge is unpreserved, and reversal is not required here because defendant took the stand and did exactly what he wanted to do. He acknowledged that both the court and his attorney had warned him that his criminal history could be admitted if he opened the door, and he stated that although he knew it, quote, would probably be prejudicial, he, quote, decided to go ahead and open the door so the jury could hear the truth. By design, defendant wanted all of this information before the jury because he wanted to tell his version of the facts, which was completely at odds with his entire criminal record. And even assuming that the testimony was error, the jury's verdict demonstrates that it was harmless and that they did not use it for propensity purposes. They acquitted him of the charges relating to Wellickson, and they also found that he had established the affirmative defense that whatever he used during the robbery was not a loaded and operable weapon. And for those reasons, this court should affirm the court's modification of the Sandoval ruling. Unless there are any other questions on the remaining points, I will rest on the brief and ask that you affirm. Thank you.
Thank you, counsel.
The prosecution's interpretation of the colloquy is incorrect. You need to look at the context of everything here. Mr. Wells had also a related Bronx case that was before this court, and this court found error in the suppression hearing, but harmless error. And then it went to the Court of Appeals, and they found harmless error, and then it went back to the lower court, and the Bronx decided not to prosecute. And so based on his representation of himself in the suppression hearing, he's able to file motions there and found that that was a way that he could prevent a conviction. And so in that context, he was here then thinking, okay, this court had also remanded this case for a new suppression hearing, which one of the problems here is that Judge Convisor, who just got the case, she wasn't involved with the case previously, so she was unfamiliar with all the complexities of this case. She thought that this went to trial before remand. She thought that this was only going for a retrial. She didn't know this was going to a suppression hearing. So during the colloquy, Mr. Wells was trying to explain, this is going to a new suppression hearing. I have motions regarding prosecutorial misconduct, and this is why I think this isn't going to go to trial, because I have all these motions that lead to suppression of evidence that's going to lead to no trial being needed. And so therefore, that's why nothing about that was about him saying, I'm going to file motions to delay the case or anything like that. And why do we know that? Because even Justice Convisor never made that a basis for her decision. The only basis for her decision was that he didn't answer any questions. And the record shows he answered every single question he answered. The prosecution here and in their brief doesn't mention any question that he didn't answer. And the second basis for the denial was the court saying he didn't leave me comfortable with the sense that he could handle this. Well, just because someone is not knowledgeable in the law isn't a proper basis to deny a pro se request.
Well, see, I think, and we're on the red light, but there was such a long period, 2 years, where he could have made a request for counsel, or that he wanted to represent himself, and he never did that.
He made the request in January, And then he again mentioned it while his Article 78 was pending when the court wasn't taking any requests. And the court said, no, I'm not doing anything with this. And then once Article 78 was decided, then he goes in December and says, hey, so what about my pro se request? And the court gives these two reasons. No, I denied it on that date because of these two reasons. And so once that court decided against his pro se request, there is no need for him to keep
No. She
requesting.
said, I denied it based on the fact that you didn't answer my questions and you didn't leave me comfortable with the sense that you could handle this. If you want to make that application again, you can, and I will hear you. She specifically said, if you want to make it.
Yes,
and
I
then 2 years happens, he sees her several more times, doesn't make the application again, correct?
Why? But why would he have to make another application once she denied it?
Because
If he's
she
gonna make
said,
the same,
make
if he's
it
gonna make-
again.
I'm sorry.
1 second. She said, if you've got something else that you want to tell me, and I'll hear it. She didn't say, don't make it again.
But here's the problem. If the basis for her denial there is incorrect, then this was reversible error. And so if he doesn't make any other arguments, then okay, if the arguments here were improper and her bases were improper, then the pro se request should have been granted. And so that's the argument here.
Thank you, counsel. Thank you both. Smith versus Kiby Hotel.
Good afternoon. If it pleases the court, my name is Mark Grotberg, and I represent the appellants in this matter. Very simply put, there really is no question of what the situation is here. There is no duty of care owed by my client to the plaintiff. The only party opposing this motion, and now subsequently the appeal, is the co-defendant. The plaintiff has not submitted opposition. The evidence is abundantly clear that this incident occurred on a public sidewalk over which the appellant has no dominion and or control.
How was the videotape in this instance authenticated?
It's authenticated by having no challenge to it being submitted. It was produced in discovery.
So you don't have a. It's your motion for summary judgment.
Understood.
So you don't have any burden to authenticate the videotape and the documents too, for that matter.
I'm sorry, I didn't hear the word.
You don't have. Are you saying that you have no burden on summary judgment in the initial instance?
I'm saying as a matter of law, the cases support the argument that if it is not challenged, it is not an issue presented to the court.
No. If you have admissible and non-admissible evidence together, then if they don't challenge it. But you have no admissible evidence, none, not a zip, nada.
No, that's not correct. It becomes admissible because it hasn't been.
Let's assume that that's what I think the law is.
I understand that.
Did you put in any admissible evidence? Let's start with that.
Okay, well, let me cite to case law that
I
says.
just want to know. You and I can disagree. I don't want to waste your time about it.
Right.
Did you put in any admissible evidence?
Based upon the New York law, yes.
What did you authenticate?
You're asking me if it was authenticated. The answer is no, it wasn't authenticated.
Is there any admissible evidence?
What's that?
Anything under oath? Anything by anybody who has knowledge of the facts? Anything?
It is, as a matter of law, admissible. Okay. I'm saying to you, the answer was no already. I've said that.
Right. Okay, so we agree. So if an attorney puts in non-admissible documents and just attaches them to an affidavit, you're saying that that is sufficient on a summary judgment motion?
Yes, absolutely.
Okay.
The case law is very clear on this. It says, and let me cite to the case because it's very on point. Okay. Sorry, let me put that aside. I should have the access to this. And so, the state, okay, there is one case. As a genuine, this is cited by the Court of Appeals. As a genuine matter, a court should not examine the admissibility of evidence submitted in support of a motion for summary judgment unless the non-moving party has specifically raised that issue in opposition to the motion. I don't think that's any clearer. That's definitively stating that even if you submit inadmissible evidence,
Okay.
it becomes admissible if the other party
video-
doesn't challenge it.
And you're specifically talking about the video?
What's that?
You're specifically talking about the video that was?
Specifically talking about the video, which is really the only evidence
How do we know?
for dismissal.
How do we know what that video relates to? I mean, it shows a fight, but how do we know it's, or how do we, yeah, how do we know it's this specific
It
incident?
shows
How
that
do we
they
know
were on a
that?
public sidewalk, which we
Yeah,
have
but
no
how do we know
dominion
it's
and
the
control over.
specific people? How do we know it's the specific people in this particular case? How do we know that?
Because it wasn't objected to. Because the party that is in the video, it was served on. And it was never objected to, never challenged. In fact, the plaintiff adopted our recitation of the facts and the procedural history in response to and adopted it, incorporated it in their response in opposition to our motion. So they have not only not challenged it, but they accepted it on its face. And that also, as a matter of law, is sufficient to establish that that is admissible evidence.
What about the on-site manager? What about the duty to have an on-site manager?
That's a separate issue, and I would argue, first place, this is what I think is a pretty common thing that's happening right now. The city of New York has taken over a whole series of hotels in the city and then used them for the sole purposes of housing homeless individuals who may have been affected by COVID. Now what they're saying is, despite their contract, they are saying that we're not honoring our contract because you haven't authenticated it. They've never challenged the contract. They've never insisted that it's not a valid contract. They're simply saying it's not authenticated. The bottom line is we haven't been able to depose the city yet, and the city still hasn't, or excuse me.
But doesn't that go to really the heart of the issue here as to whether the motion is premature? I mean, isn't that what we're really discussing?
I don't need both of these. This one is secondary. The only argument I need to make is that there was no duty owed to us.
Got it. We'll get you on reply.
Okay. Thank you.
May it please the court, Nicholas Calabria with law firm of Omni Demers McManus for the respondent Bowery Residence Committee. I just heard a whole lot of statements that there was no objection.
Did you object to the
Oh, yeah.
videotape?
Oh, yeah.
You're the respondent here, right?
Correct.
Below, did you object to the videotape?
Correct, and I'll.
Is there anything connecting that videotape to anybody in the world? Could have been three
Could have
people.
been, we don't know.
You don't know.
We don't
right?
know.
No one's
And-
been
and
deposed.
Besides that, okay, say it was there was an assault there on the street and it was captured. The complaint alleges that there was an assault in the hotel. So if there was it continued out in the street, or did it start in the street and go to the hotel? I have no idea. We just have this one tape. That's all we have. But our opposition, page 267, page 269, and the whole point 3 at page 270, we were objecting to the evidence not being authenticated. We have contracts that were these are the contracts that were in effect. We're not a party to the contract. It's with the city of New York. That's not us.
And the movement moved against you also, right?
Correct.
Not just
So I have cross claims,
Right.
and
So,
I'm
right.
saying it's their duty.
So with respect to you, you did object to the authenticity.
Correct. from 267, 269, 270. We have a whole point about objecting to that the evidence is not admissible. So I don't know where, and this didn't come up until the reply, so I didn't have an
So
opportunity.
let's just get beyond that and sort of get a little more to the merits. In the agreement, is Kicksby required to provide security on the perimeter?
There is a long list. Yes, there is. There's mentions of security.
And so what does perimeter mean? Does it mean the sidewalk? Does it just mean the edge of the building?
Well, at the moment, I don't know where this assault occurred. Again, the complaint alleges it occurred in the hotel.
If it occurred inside, clearly you say they have a duty.
Clearly.
And if it continued going outside, you say the duty is continuing under those circumstances?
No, I'm just saying, I'm not the plaintiff. I'm not the one that's saying I got beat up in the hotel. It's a complaint that was served on me. I answered. I cross-claimed. And I don't know. I don't have access to the plaintiff. I can't get his affidavit and put it in. Now,
Has there been any discovery?
that would be nice, wouldn't it? Depositions.
Does that mean no?
No, I want depositions.
So
in this
is there,
case.
no, I think the question is, has there been discovery at all? It was a.
Guess there's yes.
Okay, the plaintiff has never been deposed in the case. A couple months ago, the plaintiff's law firm, because they were not complying with orders, moved to withdraw as counsel. There's a 90-day notice that's been served. There's a stay involved. No, I have not gotten a deposition of the plaintiff or of.
Can I just ask this question? In terms of Exhibit A in the city standard terms and conditions where it says that Kicksby is to provide security service as it typically provides in its normal perimeter security, how would discovery, I guess, resolve that?
I would think that they would say what that meant. I was not a party to the contract. Now, there's the city of New York. I'm not the city. And it's Bigsby. That's their contract. So they're writing in terms and saying, well, that doesn't mean security.
You're operating the shelter pursuant to a separate contract with the city of New York?
Correct. We're putting the residents there.
You put the residents there. So what relation, oh, okay.
So I have no relationship
You don't have
at
a
all.
contractual relationship.
None at all. So there's an issue of who has the duty in this case. And I'm saying they do because I'm looking at this contract and it's talking about that they have to respond immediately to inadequate safety situations.
And so the video, we're talking about perimeter, though, if the video shows outside, does that resolve the issue in their favor? Or could it resolve the issue in their favor?
Maybe if the plaintiff was deposed and said nothing occurred in the hotel, this all occurred on the sidewalk, I'd be moving also for summary judgment. But the plaintiff hasn't been deposed. The complaint says that it occurred in the hotel. Page 30 of the record. Paragraph 66, he was assaulted by John Doe inside the Kicksby Hotel. I mean, that's what it says. I believe that under 3211A7, the pleading should be liberally construed. They accept the facts as alleged in the
Isn't this a summary
complaint.
judgment motion?
It's both.
It was both.
It was both. That the non-movements get the benefit of every favorable inference. That the facts alleged fit into any cognizable legal theory. Yes, it does.
Thank you, counsel.
Should be affirmed. Thank you.
Thank you, Your Honors. I'd just like to say I'm really surprised because there's like a whole series of half-truths and actually inaccurate information
Okay, so
being
let's
conveyed
just deal with what counsel said.
Okay,
Counsel, hold
let
on.
me do that.
Let me
because
ask my
the bottom line.
Wait.
Go ahead, Your Honor. I'm sorry.
okay.
I apologize.
The complaint alleges that the incident occurred inside the hotel, correct?
No, it says in or around the
Well,
hotel.
in to me means inside.
It
or could be-
would. It would, but that's not what occurred. That's not what occurred.
How do we know that?
I know because I have provided the surveillance video from
okay,
the date of the accident.
Hold on. In terms of that video and the contract which says perimeter, and then you have a video that shows outside, is that not perimeter, or how would we know that? Or would that be something that discovery would resolve?
Okay, first place, when we talk about the perimeter, okay, I can't define what that means, but what I can tell you
Who
is...
could define what that,
If I can just finish
who
my-
could, no, let me ask the question, Who could define what that means?
It doesn't really matter because we're not responsible for the sidewalk where the accident
It
occurred.
says perimeter.
So what?
So what?
So it doesn't, the
Isn't the
state
sidewalk-
doesn't impose
Is this-
legal laws based upon a contract. It's based upon what the statutes of New York say. We don't owe an obligation. Neither do they, for that
But if-
matter.
Right, but if you're...
I don't even know why
What
they're
hap-
imposing us, because
Counsel,
the
I don't know,
motion should
you're
get them out of
talking
the
over all of us, and I don't necessarily know if you're taking time to listen to our questions so that you can
I
answer them.
apologize. Please, go ahead.
Okay?
Yes.
Because if we have a contract that says perimeter, we don't know what that means, but we have a video that shows outside that could also be perimeter. Maybe there's something special written into the contract, and we're just wondering if discovery might not resolve that. We're not, maybe
Yes,
you'll win later
understood.
on summary
respond to
judgment.
your question
But
specifically
right now,
Yes. The fact is that we have, this is what I'm saying by inaccuracies, okay? I don't know. I've been dealing with this case for a long time right now. We have constantly provided discovery, and so has the plaintiff. The only party that hasn't provided any discovery is the one that's sitting next to me right now. I am about to make a motion, a separate motion, to preclude them because I have not gotten any documentary exchange.
Counsel, we've heard enough. The red
Can I
light's
just say
on.
one? I'm sorry.
But about this, about something on this record, not about what's happening down below. We're not interested in that. So go ahead.
That's fine.
Your last
Bottom line, and this is why I'm sorry, I may be getting a little frustrated. The bottom line is this incident occurred out on the sidewalk. There is law that determines who's responsible for the sidewalk. The sidewalk law was implemented solely for the purposes of repairing the sidewalk flags and making replacements and so forth and so on. The city abdicated its responsibility to the landowners for whatever reason. I understand they'd prefer not to have to pay for those. But they did not make policing part of the obligation. They could have in the statute, but they didn't. And as a result, the sidewalks are not the responsibility of the landowner.
So what you're saying essentially is that sidewalks aren't part of normal perimeter security.
That's correct.
Okay, thank you. Got your point.
Thank you. Thank you, all.
Kadem versus Stonehill. You may proceed, Counsel.
Good late afternoon, Your Honors. I'm Eugene Goldberg with Gallup Dryer in Berkeley, representing appellant John Kadem. The issue. This appeal involves the shadowy borderline between tort and contract. It raises the question of whether tort duplicates contract. Kadem contends that where there's a bona fide dispute as to the contract's material terms, it's not possible on the 3211 motion to separate tort from contract. There is also a conflict here as to between individual liability, malpractice liability, and the duplication tort contract issue. Who's who in the appeal? This appeal involves a client-architect relationship between Kadem.
We're familiar with the case. So
Thank
why
you
don't
very
you
much,
get
Your
to the
Honor.
merits?
The ruling below, the client pleaded 3 causes against the architect: breach of contract, negligent, and malpractice. The same $13.5 million damages were sought in each. The malpractice cause was also pleaded against Meltzer, the individual involved in this. On a post-note of issue 3211 motion, the court below held that there were the same factual facts and damages were sought for each cause, contract duplicated tort. The court below held that economic damages could not be sought in malpractice against the individual Meltzer. Because the architect was vicariously liable for Meltzer, no claim in malpractice lay against Meltzer. The facts. The client, by the way, appellate review here is de novo, limited to the record. The facts. The client, a doctor, involved the architect Stonehill in investigating and preparing plans for a renovation in Manhattan. There was no written contract. After 17 months, client and architect had a falling out. Architect brought a mechanics lien foreclosure action,
So with respect to the negligence claim, what, aside from the fact that the firm didn't comply with the requirements of the contract, what separate tort have you alleged?
The client, the individual was,
Well, that's on against the individual. I'm talking about the firm. The firm has a contractual obligation with you. They're not disputing that there's a breach of contract claim. They're not disputing your, at this point, any
they
of
are
your
disputing the
damages.
contract.
They're not disputing the
Yes, they
damage.
are.
How?
We contend that the architect was a specialist. They're not even contending that. There's a dispute.
They are not disagreeing that they had an agreement with you to do these services. So let's assume that, okay.
They are very much.
Well, we'll establish that. It's okay. We understand your position.
Okay. And maybe we'll ask the respondent whether they're disputing that. But
Because
let's assume,
this is a
what
3211
separate, I'm
motion.
asking you again, what separate tort have you alleged?
We've alleged the architect did not live up to a specialist duty of
That's
care.
the architect. You have a malpractice claim.
That's against
That's a
the firm.
different thing.
The firm is an architect. It's not the, and there's also a claim against the individual who's particularly involved in this.
Correct. But how is that different from you were supposed to do this job in the way, a good and business-like way, and you didn't do it? How is it different?
Because the architect contends that that is not what the contract was. The architect says the contract was simply this. You've asked us to provide services, we've done them. That's it. No more, nothing else in the contract. The contract is completely silent.
Are you
Nothing as to
literally
fees.
saying you didn't provide those services?
We're contending that they did not provide them competently within the
Doesn't matter
specialist-
whether it was competent or semi-competent or not competent. You didn't provide what we contracted for.
No, we're contending they didn't meet the standard of due care that they were obliged to perform as a specialist in this area.
All right.
Under the
And
architect's...
you think that that gets you around Clark Fitzpatrick?
Excuse me?
You think that gets you around the Court of Appeals case in Clark Fitzpatrick?
Because the answer here is that was a complete contract. Here we have a very incomplete contract. There's not a written contract. There's a
So it only
dispute
applies, wait a minute, so it only applies to written contracts?
No,
and
it
not
applies to
oral
complete
contracts?
contracts. Complete contracts.
Complete
With all the
contracts. Got it.
terms between the parties. There is a complete absence of terms dealing with scope, duty of care.
So why don't you deal with Meltzer,
Excuse me?
Deal with the individual.
The individual here, the individual was...
Can he be held liable for his own negligence under the BCL?
The individual is liable because of a statute. BCL 1505 provides that each shareholder, employee, or agent of a professional service corporation shall be personally and fully liable, and I emphasize that, and accountable for any negligence.
And of course, sir, you have no breach of contract claim against Meltzer.
That's exactly. We
Okay,
didn't
got your
contract
points.
with him.
Thank you.
Thank you, Your Honor. I have a few minutes.
Oh, you will have, no, absolutely.
May it please the court, my name is Kevin O'Neill from the firm of Byrne & O'Neill. I've got the respondents, Stonehill Taylor Architects, and also Henry Meltzer.
So is there, in this case, an independent, well, actually, before we do that, can we establish whether or not you agree that there is an oral contract to perform architectural services?
Yes, there is. And that contract is alleged by the plaintiff, so it's a judicial admission by the plaintiff. But there was also a prior lawsuit by Stonehill Taylor Architects for breach of contract against them, alleging the existence, against John Kadem, alleging the existence of the contract between the parties upon which the architect wishes to rely to obtain payment. So this lawsuit, and this lawsuit references that lawsuit because he literally says in the
There's no
complaint.
doubt in your mind that there's a contract. And there's no doubt in your mind that you have to perform under the contract in a way that would make the contract
Professional.
right, right,
Yes.
exactly.
We entered into a professional services
Right.
contract, and so we
Yes,
have
all
to
right.
act in accordance with good and accepted
And you
professional
haven't
care
moved
and
to
practice.
dismiss that claim.
We did not move to dismiss the breach of contract cause of
Let's
action.
talk about the individual architect.
Sure. The appellant relies upon BCL 1505A, claiming that somehow it establishes a new cause of action that should cause the court to turn
No,
a
it's
blind
not
eye.
a new cause of action. He's suing the architect for malpractice.
Yes, and turn a blind eye to the New York State common law, which says that under the circumstances, you have no right to do that.
Oh, wait a minute. Let's talk about the common law. You're talking about Clark Fitzpatrick, I assume, right?
Correct. And I'm also talking about
But in
Dasby.
Clark Fitzpatrick, as your adversary pointed out, there was a quote-unquote complete contract. I may not go as far. There's a contract there. Is there a claim of a breach of contract against Meltzer?
There is no claim of breach
So
of
then,
contract.
so the
against
whole analysis that we do with respect to Stonehill and the contract claim is different, right? From the analysis we do with Mr. Meltzer with respect to the tort claim.
I would say it's different, but it's also the same. There were several arguments made. There were 3 arguments made for the dismissal of the tort causes of action against both respondents, and they all apply to Henry Meltzer as an individual. Number 1, that you can't transform a breach of contract into a tort.
But he doesn't have a contract, so there's no transforming. That's not, so let's get that one away. 'Cause
Correct.
there isn't any contract between the two.
Correct.
So that doesn't win the day. What's the
Right.
next one?
Well, New York's economic loss rule, which says that you cannot seek.
Except lawyers get sued for money damages and malpractice claims all the time.
And the Court of Appeals has specifically addressed this issue with regard to design professionals. And with regard to design
And said
professionals,
you can't-
they
you
say you
can't.
can't do it.
No, you can. You absolutely can. How can you sue a law? How can you sue a law firm for malpractice without getting money damages?
Well, but the Court of Appeals, I'm talking about Dasney versus Sampson, Summer versus Federal Signal, they've told you when you can sue a design professional services corporation in tort.
Corporation, right.
No, but they've also said when you can sue anyone. But there's no tort cause of action because otherwise the law of contracts drowns in a sea of tort. And this exception, if you were to read it this way, 1505A didn't change the common law. It codified it. We all have personal liability for our torts. For our tortious conduct.
Right, exactly. So I don't understand what your argument is. Because the plaintiff's seeking money damages, that knocks the case out?
Correct. Because
Then how could you sue a lawyer for malpractice?
the Court of Appeals, specifically with regard to actions against design professionals, has said there's no cause of action grounded in tort, and this is separate and apart from the duplicative contract and tort.
But that is because in those cases, there's a contract, and so what we say in all these cases is you have to allege a legal duty independent from the contract.
Yes.
That's the analysis.
And saying that just breach of a duty of due care doesn't get it done.
I agree, but that's with the corporation. This is with the individual for his own alleged malpractice.
Yeah, but again, the courts in the state of New York say you got to look at the damages, because otherwise you've created an exception that swallows the rule. Now they forget about entering into an agreement that limits your liability, that shortens the contract limitations period. Just sue the individual in tort.
If Meltzer was part of, if you had a written contract and Meltzer was a signatory to the contract, then that's the end of it.
If he was a contracting party. But again, the New York State Court of Appeals has not said that you can sue for economic losses in tort.
But the First Department has said it.
In what case?
I'm thinking.
17 Vista Fee Associates versus Teachers Insurance and Annuity. So that's a case from about 25 years ago where we said that the fact that the plaintiff suffered pecuniary losses is of no significance in a malpractice claim against a professional.
Right, and the Court of Appeals, I think, would disagree based upon Dasney versus Sampson.
Thank you. Got it.
Look at it.
2 minutes, counsel.
Thank you for reading my briefs, Your Honor, and where I cited 17 Vista. I do want to point out that the claim that the defendant, Stonehill, has not conceded are the terms of our contract. They dispute that. Therefore, we have a claim in alternative against the architect. What if we're wrong in proving that what the terms of the contract were? That's why we've pleaded an alternative claim. If we're wrong, we will then be able to go and malpractice against them, and that needs to be preserved. I need a stipulation from my adversary to the effect that they will concede that the contract terms are as we have pleaded them in order to be able to preserve a contract claim. I don't want to face the situation where later on at trial they're going to say, no, you didn't have a contract or the contract didn't cover that.
I think I heard your adversary say 3 times that there is a contract, and he could not sue your client for breach of contract without an underlying contract claim. So I don't think you have a concern in that area.
The difference is between, do we agree on what the terms of the contract is? We have a dispute as to that. And that's a very great problem when we must be able to preserve our tort claim, our malpractice claim, and it's with the architect. Can you order I don't think you can order here that my adversary concede what the terms of the contracts are. If he was not willing to do that, I need to very much preserve my tort claim. That's why we should be able to do a claim, an alternative against them. If you have any other further questions, Your Honor, I'd be glad to answer them.
Thank you both.
Thank you, Your Honor. Good evening to you.
People versus Johnson. You may proceed, counsel.
Thank you, Your Honor. May it please the court, my name is Paul Wiener, appearing for Joseph Johnson. Joseph Johnson spent 8 years in prison for a crime that he did not commit. The prosecutor's entire case rested upon the complainant's testimony that she was raped at knife point, but the jury rejected that story and found that it was not true. They found that there was no rape and no knife. Thus, it acquitted him of all of the top 7 charges which had to do...
Let me ask you a question. The fact that he was acquitted on the sexual assault and rape charges, does that negate his intent when entering the apartment?
There's absolutely no evidence that... Look, one of two things happened here, Your Honor. There was either consensual sex, as Mr. Johnson said in the controlled phone call, or there was a knife point rape as the complaint.
Right, but we're talking about the burglary charge specifically, which at the time of the entering,
yes,
the intent is formed.
But my point is that there's no alternative in the facts here. There's no possibility that there was anything other than...
But can I suggest a third possibility to you? That the people didn't prove the elements of sexual offense based on conceitedly very inconsistent testimony. All right?
I'm sorry, say that again.
That they didn't prove the elements of the sexual offense.
But there was no evidence that, there was just nothing to support that. And look.
So is it your position that the only way you can sustain a burglary charge is if the crime committed therein, the person is found also guilty of?
It's my position that you can only sustain if there's an intent to commit a crime, but there's no evidence that there was an intent to commit a crime. The jury was given a very narrow charge as to intent here. The charge was you can only find intent to commit a crime if one of the above, you have to be able to find an intent to commit a crime, one of the above charged crimes, all of which he was acquitted, or a crime involving sexual conduct without consent. There wasn't a shred of evidence. There wasn't a shred. He was acquitted of all of the all of the above charged crimes, all of the charms.
What about his statement in the phone call to her that this will never happen again? Maybe the jury found that that wasn't enough to prove the rape, but was enough to prove his intent when he took her into an apartment under construction that wasn't his, that he'd never ever been in before, to have sex. Maybe the jury, I mean, why is that repugnant?
Because, Your Honor, look, first of all, we're not saying it's legally repugnant. We're saying that the verdict is against the weight of the evidence. In terms of that specific thing, first of all, that was an extremely vague comment. On page 9 of my reply brief in the second footnote, what they left out was that he said, I did not do anything without your consent. I did not do anything. That's what he said. I urge you to listen to that controlled phone call. It just doesn't, he's acquitted of all of this. It doesn't make any sense that he could have been convicted of the intent to commit a crime here. There was absolutely no evidence that he had committed
Why couldn't the jury have believed that when he entered the apartment, he intended to rape her, but that the jury felt that the elements of rape and sexual assault hadn't been met?
Because there's just, it just doesn't really.
I mean, what you're arguing is like there's like a logical inconsistency, but doesn't the law recognize?
I mean,
this
they rejected all they rejected all of these sexual. They rejected rape in the first degree. They rejected predatory sexual assault. They rejected sexual abuse. They rejected the entire array of sex crimes. The jury found that it makes no sense that other than the jury thought that there was no sex crime here, that there was no.
Well, obviously they didn't because they found him guilty of burglary.
Because
you're asking us to reweigh that evidence. You're not saying it's
I
repugnant.
think what happened is they thought that he was probably guilty of trespassing. They weren't given that charge. This was the least, this was the 8th charge. They thought it was the least serious charge, and they were probably confused about the charge that the judge gave. This charge. In fact, it's important to note that they asked for a recharge on that. That is the only thing that makes sense. If this could be a case where there might be some evidence that he had committed some sort of sexual, there's nothing here. There is, it's either consensual sex or violent rape at knife point, and the jury rejected that, and that makes total sense because her story was filled with all of these inconsistencies and lies. Even the police said, "You have no credibility. You've made so many lies."
Yeah, but doesn't that go exactly to the point that we're trying to make? That the jury did not believe that the elements had been proved, not to say by.
But I would agree. I understand what Your Honor is saying, and in another case that might make sense. There isn't a shred of evidence that he committed any kind of a sex crime other than this knife point rape.
Okay, thank you. Let's hear from your adversary, and then you'll get rebuttal.
Good afternoon, Your Honors. May it please the court. Jonathan Scola for the people.
I mean, you have to admit, counsel, right? If someone is found not guilty of all of the crimes they're in, that is, kind of at odds of the person breaking and entering to commit a crime they're in, or is it?
It's not at odds. So this court owes the jury deference and should not pierce the invisibility cloak of the jury's deliberative processes as long as there's some rationale for its decision.
What's the rationale here?
So there are three potential rationales as I see it. So the jury could have concluded that defendant intended to commit a sex crime but ultimately didn't, or that the people didn't prove it. Could have concluded that the defendant committed a sex crime that was not charged, or could have exercised mercy. The Court of Appeals is very clear that
the jury nullification.
Exactly, Your Honors. Any one of those three is plausible here. It's not
So could the first one be that he went in there thinking, they found that he went in there thinking, I'm going to have sex with her whether or not she agrees, and at the end of the day, she didn't fight enough or didn't make it clear that she was not wanting to have sex, which would be consistent, right? That he was
Exactly,
going to
Your Honor.
go in, he took her in, he was going to have sex with her whether she wanted it or not, but at the end of the day, she didn't make it clear to him that she didn't want sex, or at least that's what the jury found. That would be a consistent verdict.
Exactly, Your Honor. That's a possibility. The only way a verdict is repugnant is if it's impossible. There's no way to reconcile. And I just gave you 3 ways. Your Honors alluded to other ways. So he talks about the holes in Aisha's testimony. Let's discuss what Aisha could not have lied about. She could not have lied about the unlivable conditions of the apartment, the non-functioning toilet, the paint cans everywhere.
I don't think that part of it is in question. The question is the crime they're in, really.
Sure. So she could not have lied about undergoing an invasive sexual assault examination. She could not have lied about the DNA evidence showing that it was there was strong support for that they did engage in sexual intercourse. She could not have lied about the fingerprint evidence putting defendant at the scene.
We agree. It's the question of intent, his intent, that is the tough part here.
Of course, it's tough. And she also couldn't have lied about what he said on the controlled call. Now let me read you a little bit of the controlled call. Aisha says, "If you're really trying to make me come see you again, I'm trying to understand that this is not going to happen again." Defendant says, that will never happen again. That will never happen again, I promise you. What could he possibly be saying will never happen again if everything was consensual? There's never going to be, in these cases, usually not going to be direct evidence of intent. It's all based on circumstantial evidence. And here, the jury already weighed Aisha's credibility and the other evidence and concluded.
What's the circumstantial evidence as to intent here? Is it the fact that they enter that he takes her into essentially a stranger's apartment, unrenovated apartment? What are the circumstances?
Sure. So there are a few things. One, the circumstantial evidence is Aisha's testimony, her prompt outcry, the fact that she subjected herself to an invasive sexual assault examination, the controlled call where he admits some wrongdoing, at least, the DNA and fingerprint evidence, the fact that he approached a 21-year-old woman at 6 a.m., brings her to a vacant apartment building that he clearly didn't live in and very likely had no connection to. And what kind of man does that? What could his intent have been? We submit that, as Your Honor mentioned, I'm going to have sex with her whether she consents or not. And whether she consented was, up to the jury, and the jury concluded as it did. We ask that you affirm. Thanks.
Thank you, counsel. Rebuttal?
Yeah, look, I just want to really drive home here that there are no facts. Otherwise, they would be standing up here and saying, these are the facts that show that there could have been some other incident,
But isn't counsel right? The only way to determine it is through circumstantial evidence here, and just the circumstances here are different.
Look,
right?
She's told, Your Honor, first of all, she told so many lies. Again, it's in my brief about the alleged incident, about returning to the apartment, which was contradicted by her sister, about her.
Which may go to why your client was acquitted of the sexual assault or rape charge.
It does, but it doesn't make any sense that the jury finding all of these, that he's not guilty of all of these sex crimes.
But how about what my colleague suggested? I'm sorry. How about what my colleague just suggested in her questioning, that he was going to have sex with her whether she consented or not?
There's nothing to support that. And as to the control...
Well, okay, but he takes her into an apartment that's unrenovated. He doesn't live in the apartment.
They were going to have... They had consensual sex. That's what he said. And I just want to say, in terms of this controlled phone call, what's left out is complainant. This is not going to happen again, Mr. Johnson. It won't. Complainant, something I didn't want to do. I did not. If you want me to stop, I will stop. And I said, I'll give it. That's left out. He doesn't say anything in that controlled phone call. Please listen to the controlled phone call. He is shocked by this. He's just calling her and saying, can we go out for a movie? Can we go out for dinner? The jury, there is nothing else to suggest that, again, I come back to, it was either consensual sex or a violent rape. There's nothing in the facts here to suggest that it was anything in between. And I urge you, this is a really grave miscarriage of justice.
Thank you, counsel. Slogerloff. Anytime you're ready, counsel.
Good afternoon, Your Honors. May it please the court, my name is Stephen Uden. I'm with the law firm of Bernard D'Orazio, and we represent the appellant, Helen Slogerloff, in this case. At its core, this is a very straightforward fraudulent conveyance case. Appellant, through her petition, through motion to re-argue, through the appeal, has issued one theory.
Do you want to deal with the res judicata, the finding of the court below?
Well, right. So the res judicata finding on re-argument, we believe surely was an error. Res judicata does not apply here.
Why is that?
The two proceedings that the lower court linked are entirely different. They seek different relief. they target different respondents to inject fraud, which is the subject of our case, into the prior proceeding, which was really to secure a placeholder, because the subject is a co-op. It's not a condominium.
So you are, in that action, you were seeking to enforce the judgment, right?
There's a judgment enforcement.
And this action, you are seeking to enforce the judgment, correct?
The first action, we were not.
Why would you put a lien on a property except to, how could you possibly put a lien on the property except to enforce your judgment?
Yes. I mean, that,
That
to
you
extent,
did.
That's true.
This one, you're seeking to enforce the judgment, correct? You may be using different methods, different parts of the CPLR, but both those actions are seeking to enforce the judgment, correct?
Yes, but
So
against
why
different
in
parties.
the first one didn't you make all claims to enforce the judgment? You had all the parties. Why not?
It made no sense, and it was inconsistent to inject a fraud claim.
It doesn't matter whether it was inconsistent. You can plead in the alternative. Everybody does in every single case. Why not just throw it all in the pot? That's what you're supposed to do, right?
Well, not always, no. It
fair
depends on the situation.
Right.
We thought that this situation, and we think this situation is different because.
Well, in this instance, was there an identity of parties was there an identity of parties here?
On paper there was, but there was no relief sought from the respondent, Natalie Scola. If she was.
So you're saying that she was a nominal party?
She was completely a
Now,
nominal.
the co-op was in the other case?
The co-op was in the other case.
Because you wanted to sort of stand in line after, I guess, the mortgage, you know, which of the bank.
It was a placeholder so that we would be, because we can't get a lien because it's a co-op,
I understand.
not a condominium. But we sought no relief from Natalie.
Okay, so let's go to the merits. So with respect to the 276, which is the fraud claim, the actual fraud, are there any issues of fact with respect to Dimitri's transfer of half interest of the co-op to his wife Natalie without consideration?
Well, the whole case is a transmutation of Dimitri's personal assets into a jointly owned, protected asset for no consideration. It just very simply, the context is that in 2019, Dimitri owed the appellant close to $700,000. He had money. He marshaled all his liquid assets. He came up with $1 million. Did he pay?
Did Natalie compensate Dimitri for the half interest in the co-op?
I'm sorry?
Did Natalie compensate Dimitri for the half interest in the co-op?
Not at all. No consideration changed hands, not a dollar left Natalie's pocket.
She stated that on the record at a deposition or something, that she did not use any of her money.
Crystal clear. She said she used none of her money. She didn't contribute to the down payment. And her testimony was 4 years after the purchase. And even then, she said, I've paid no maintenance. I've paid no mortgage. I don't know if the mortgage is being paid. Dimitri handles it all.
He's in
She gave
charge.
no consideration. The fact that she signed a mortgage note, which the other side makes a big point of, is really a red herring, in our opinion. It doesn't amount to consideration flowing from Natalie to Dimitri. There was none. It was all Dimitri's money.
And does Dimitri continue still to benefit from the apartment?
Well, they both live in the apartment.
So he benefits from it?
Sure, he benefits because he used his own money and he bought an apartment. And the crux of it is that he did so when he owed a substantial debt to his former wife, and he thumbed his nose at her and said, I'm going to buy a co-op, put it in the name, a joint name with my new wife. It's now protected, and it's now beyond reach.
And the judgment of divorce was entered when he bought that apartment?
I'm sorry?
Was the judgment of the divorce entered when he bought the apartment?
Yeah, the judgment of divorce was from 2013, and money came into Dimitri's hand in 2018 that he was supposed to share with Helen.
That was the liquidation of the Infotech?
Right, and he didn't share that. Instead, he took all that money, and by his own testimony, he said, I used my personal savings, and I used the InfoHedge liquidation money that flowed through Das Capital, which at the time he owned 99% of. It's all in the record. And I used all that money to finance and buy this co-op. And it left me, he said, with de minimis liquidity. And he never paid the debt owed, and it clearly was a fraudulent conveyance under the debtor creditor law. And if I could just make one last point, I know my red light is on. With respect to the res judicata argument, we firmly believe that these were entirely different actions. They shouldn't have been merged together. And besides that, there's a Court of Appeals case which we cite probably both in our brief and our reply brief that cautions res judicata should not be applied too rigidly to deprive a litigant of her day in court.
Thank you,
and that's exactly what this case is. If the lower court's decision is upheld, it will wrongly deprive her of her day in court, and she's the victim here.
Thank you.
Thank you, Your Honors.
Counsel.
Thank you. Your Honors, may it please the court, they've had their day in court, actually twice, on a full hearing.
By the way, did you ever raise res judicata in your motion?
Oh, absolutely. First of all, you're going to note that it was an affirmative defense and raised.
It was an affirmative defense, conceded.
Then you'll notice that in the affidavit, affirmation, my affirmation against the petition, we're talking about page 501 in the record. It's not
You know, I tell you, Counsel, I don't appreciate phones coming out like that because I can't do that.
Well, I'm
Oh,
sorry.
he's reading from the
I was
record,
trying to
right?
read from-
And we can't.
Notes. From page 501. 501 of my affirmation says, this is the second petition brought against the apartment. In 2022, petitioner brought the same action in this honorable court.
But wouldn't it be fair to say that really the action in that action was directed at the co-op, and that Natalie, actually no relief was sought against Natalie in that action?
Absolutely incorrect. So,
What was sought against Natalie in that case?
okay, so when the apartment was being sold in that case is when the apartment is eventually sold, he gets to carve his judgment out. That doesn't tell us how much Natalie put into the apartment or didn't.
She put nothing.
I was saying, hasn't she admitted several times that she's put nothing into the apartment?
No, garbage in, garbage out. The problem is the questions being asked at the deposition were wrong. Natalie doesn't process the payments monthly. Dimitri doesn't process the payments monthly. They're auto taken out, and she's the only one working. She's the only one putting money into the joint account. So when they auto come out, they come out of the joint account. They come out of her money. But does she make monthly payments? No, neither does Dimitri.
When he put the deposit down,
He didn't. That's actually in the record, Your Honor. Das Capital is a corporation,
he's a
and we don't know the
99%
circumstances.
owner, right? Put the deposit down. She admitted that all of that money came from Das, and he admitted that the money that Das used was part of the liquidation of info whatever, the info something. He said it. I mean, that is just what he said.
That part of it, Your Honor, is not disputable. What is
Exactly.
disputable
So
is
he
that-
took his ex-wife's money and paid down and deposited on an apartment. That's all, everyone agrees, correct?
That part is not disputable.
And then at the time he did that, he owed her half that money, correct? He owed her half the info company, info hedge.
Yes, he had a judgment against him.
For that money. And instead of paying her that money, he used it for the down payment on the apartment. Are we all clear that that actually happened? No dispute.
We have no problem with that, Your Honor.
Okay.
But let's be really clear. The payment for the apartment was millions of dollars. This was not bought for a couple $100,000, which was the down payment. This was bought for her taking a loan.
She's only,
and him taking a loan where they
this
both
party's
signed
only concerned about her half of the money.
No, that's not what the case was. So this case said that Dimitri bought the apartment with all his own money. It's all Dimitri's apartment, then he put it in her name. That's at pages 16 and 17 of the record. We now know, according to their own documents, that the apartment was bought with money that was jointly taken as a loan based on her salary, because he's not earning money, and based on that money from the loan. So she is legitimately half owner. Yes, Your Honor.
Where in the record is all of that information? Because from record 244 to 245, when she's asked specifically about the down payment and the payment of the mortgage, her testimony appears to be that she doesn't know where the money for the down payment came from. None of the money was hers, used for the down payment or the closing costs, and the money came entirely from Dimitri. I mean, like, that's a statement. She says that he would be responsible for making the payments on the mortgage and had nothing to do with her. Where's the information that you're talking about?
Number one, it's in their exhibits. When they brought the petition, it showed where the down payment came from, and it showed the loan. They had the note from the bank showing the money being
Because
borrowed.
so what you're saying essentially is that she's on the mortgage, and that's her essentially her contribution?
Her contribution was that she took a loan for millions of dollars. That's a huge contribution. That is consideration to go and borrow the money to buy something.
Well, that's how everybody gets co-ops, or unless you have lots and
100%,
lots
Your
of
Honor.
cash.
Yes.
So
That's right, and that is normally how you get
She
money to buy a
said she
house,
didn't
you
use
take a loan.
any of her money. I mean, you have to also make a down payment. You can't borrow 100%
So
from the bank.
she thought the down payment came originally from Dimitri, but it came out in his exhibits that it actually came from Das Kapital.
Yeah,
which
but
he
it didn't
argued
come
in
from
oral
her.
argument.
That's the point. It didn't come from her. She didn't.
It didn't. The money, half of the other money. So remember, what you're focusing on is $200,000 or so. What I'm focusing on is millions of dollars.
Well, that's the bank's. I mean, that was the bank's loan.
That's the
mortgage.
bank's loan that she's on the hook for. That's consideration under any precedent this court has ever held. But
That's
let's be-
consideration for the down payment?
No.
No. We're only talking about the
talking about
down
two different
payment
things, Your
money,
Honor.
right? Exactly, two
Okay.
different things. We
She
agree.
didn't get the down payment from Dimitri. Dimitri didn't hand her the $40,000 and say, make the down payment. He gave down payment to the prior owners. There was not a transfer of money from him to his wife. There was the two of them buying an apartment together. That's what the judge held, and that's why, and by the way, the judge held that even if you were to consider his arguments as possible, he still didn't meet any of the criteria. He didn't come forward. Remember, this is a petition. You have to treat it like summary judgment. He didn't come forward with proofs of anything he had to come forward with because he didn't have an affidavit from his client. He didn't have a witness. He didn't present anything when he came in. Now, on top of that, Your Honor already hit that both causes of action were for the same thing, for debt enforcement. He got his 2 days in court. He failed to prove his petition on the merits, which the judge commented on directly. And by the way, he failed to name the bank. If you're going to take an apartment, this petition was a turnover petition. He wants to take the apartment from her, from their child, and from Dimitri. This is not taking a few $100,000. This is taking a millions of dollars apartment from an entire family, including a woman who's on the hook for the purchase money of this thing. That is very different than going after your rights to get a couple $100,000. And may I point out, this is very important, he says he has a judgment for hundreds of thousands, for the entire amount, against an entity, Das Kapital, that he's not even pursuing, because this is just about going after him. It's not about getting the money. He could go after Das Kapital anytime he wants. And we've been fighting for years over why he's not. If there are any further questions, but it's very important that the bank is a material party here. My motion was in biggest part
But don't
was
they
that you can't bring
acknowledge,
without
don't
the
they
bank.
acknowledge that their lien is inferior to the bank's lien?
It's a turnover proceeding. It has nothing to do with the bank goes now from having two tenants who are paying every month to having the right to prosecute a lien. That's not the same protection or the same situation. That's massively changing.
First of all, it's not massively changing. It happens all the time. People with junior liens try and foreclose on their junior liens every day. The bank is
correct.
in exactly the same position it would have been prior to.
And when you try to foreclose on a junior lien, does the higher lien have to be a party?
Yeah.
They're not here.
No.
They're not
Doesn't
here.
have to be. Never does. Doesn't have to be.
But everybody-
It has a senior lien, so.
Everybody
Is
admits
generally the
that
party.
All right. Okay.
Thank you, counsel.
Thank you.
Counsel, can you just address your prima facie case and how you think you made out a prima facie case under the debt of creditor law?
Sure, absolutely. And his characterization of what the lower court found was completely wrong. The court never mentioned we didn't submit affidavits or any other proof. We had prima
I
facie
just want you to
proof.
list what you think shows your prima facie case.
We would never have an affidavit of our client because we weren't part of the transaction, obviously. We have all of their testimony. We have testimony from Dimitri. We have testimony from Natalie. We have admissions from Dimitri in an information subpoena response. So we have documents that they both produced. That was the prima facie case that showed, as a matter of law, all of their proof that Dimitri financed it himself. He is Das Kapital. The argument that it didn't come from Dimitri, it came from Das Kapital is nonsensical because Dimitri says, I am Das Kapital. The records show he owns 99% of it. He took the money and merged it with his personal savings to put the down payment on it. as Your Honors have all pointed out, Natalie admitted she put nothing into it. She gave
Oh,
no.
so the argument for saying there is consideration is that she's on the mortgage, on the hook for millions of dollars, and also that she's making the mortgage payments. Is that consideration?
No. Two quick things. On the latter point, the only thing in the record, Your Honor, on the mortgage payment is her testimony 4 years
There's
later.
nothing in the
saying,
record?
I've never paid the mortgage. There's nothing in the record to support this automatic payment, who's making money. There's nothing. The only thing in the record, which we put as part of our prima facie case, is that I have never paid the mortgage. Is the mortgage paid? I don't know. Dimitri does it. And that's 4 years later. And she also admitted under oath that she never paid anything towards the down payment. So the prima facie case was all of their testimony, all of their
Yeah,
documents.
but what have you put in to show that if DAS put down the down payment, what have you put in to show that we should pierce the corporate veil and go to this?
There's nothing to pierce the corporate veil.
Well, you don't have a judgment against DAS.
No, well, we do, but that's a separate point.
That's not what you're seeking in this case.
We have documents. We have an accountant letter. We have a mortgage application. We have Dimitri's admissions. Those three, points of proof show that he owned 99% of DAS Capital.
Still,
And he used DAS Capital money. He said, I used DAS Capital money. When the money came in with a liquidation, I took the DAS Capital money and I merged it with my savings and I paid the down
So
payment.
it's not that DAS wrote the check. He's saying he took the money from DAS and commingled it with his money. DAS didn't make the down payment. Is that
Well,
what
they were part of the down payment.
Let me ask you, did DAS make the down payment?
No, Dimitri made the down payment.
So if we looked in the record, the check is going to be from Dimitri personally.
No, there was $1 million down payment. There was a $200,000 check from DAS that Dimitri signed. And the rest all came, the other $800,000 came from Dimitri personally, according to his testimony. We don't know how it was paid. It's not in the record, except that he says, I paid it all out of my personal money, and all the money that I got from DAS Capital, I paid it. So that's $800,000 of the million. The other $200,000 is a check from DAS Capital that Dimitri signed, but Dimitri says, I own 99% of DAS Capital. That's my company. I could use that check, and I could use any check. Nobody's buying it. It's me. I'm buying it. I'm putting the down payment on.
Thank you, counsel.
Okay. Thank you, Your Honor.
Thank you all.
People versus Kirk. Anytime you're ready, counsel.
Good afternoon, Your Honors. Anthony Balth on behalf of Malik Kirk. The hearing court erred in denying Mr. Kirk judicial diversion. Mr. Kirk clearly established that he suffers from substance use disorder. Despite this, the court failed to even acknowledge whether he suffered from substance use disorder, instead deciding to defer to the MDC court's ruling that he did not satisfy at least two criteria to meet substance use disorder. However, the evidence established below shows that Mr. Kirk clearly demonstrated at least two of the criteria, and the testimony from Dr. Green is that he clearly met at least four criteria, which would be moderate substance use disorder. She testified that he demonstrated a strong desire to use marijuana. He would wake up and begin smoking marijuana immediately and would even smoke before bed. He spent a lot of time acquiring and using marijuana, often being under the influence all day, every day.
How do we look at the factor that he didn't smoke marijuana or use marijuana in order, or rather sell the drugs in this particular, what he was charged with, to support that marijuana use? How do we look at that? That's one of the factors, right?
Yes, that's correct. It's our belief that just because there wasn't a one-on-one proximate cause relationship between the drug sales and his drug use, that doesn't necessarily mean that him being addicted to marijuana didn't contribute to the offense. And in fact, the evidence lends to the logical conclusion that his abuse did contribute to it. He was unemployed for years after dropping out of high school. And a lot of this stems from the fact that when he was a teenager, he witnessed the tragic death of his younger sister in front of
But
him.
he said that when he purchased the marijuana, he got it from his family, his girlfriend, his grandmother. He wasn't selling drugs to support that habit.
Well, I would say is that Mr. Kirk, like many people who are addicted to drugs, turn to various sources for income to do it. That meant turning to his family. But even after a while, his family started to feel bad about the way that he was using it. He had fights with his family, and then he would turn to his girlfriend. He'd occasionally dog walk. Basically,
But
he would
counsel,
do
he
anything.
denied that selling the drugs was connected to his marijuana use. Why should we say he's a liar?
No, I wouldn't say that.
So then that's the end. His drug use didn't contribute to the crime, correct?
I would disagree with that because when he was acting as an intermediary during these drug deals, he admitted during his PSI interview that during it, he was thinking about how much marijuana he was going to smoke because of these drug deals. So while he does admit that he didn't receive money for it, he has relationships with drug dealers because of his substance abuse problem. And because he was acting, as an intermediary for a dealer, it's not illogical to believe that he could have received drugs for his...
May I interrupt you for one moment and say, how are you going to distinguish our decision in People versus Boynton, which says the only relief he's entitled to is remand? You don't want remand.
No, I don't.
So there's the thing. The First Department has said last year, the only thing you're entitled to is remand.
Well, I would say that the unique circumstances of this case warrant Burwell relief. While Burwell relief is typically reserved for very low minor offenses, the offense occurred in 2017. Mr. Kirk completed his 3 years of probation. He followed everything that he was supposed to do. And because of his age and the other circumstances I mentioned in the case, I feel like Burwell relief is warranted in this circumstance.
Thank you, counsel.
Good evening, Your Honors. Michael Tarbutton for the People. Your Honors,
I wondered, to continue sort of what counsel just said, I thought that Burwell relief is usually just for relatively minor crimes. Would that be something you think is appropriate for this case?
No, Your Honors, and I think that that's dispositive for this case. The Court of Appeals in People v. Consecao refused to grant Burwell relief for misdemeanor drug possession, 7th-degree drug possession, when the case had a sentence of 2 days community service. And they said that was too serious for Burwell relief. Here, that we have 6 felony crack sales near school grounds, and them inside the grounds, on the school grounds of the middle school, inside the schoolyard. This is far too serious to simply dismiss and say this is too insignificant, too trivial for society to be pursuing. So Burwell relief is inappropriate, and because that's the only relief that the defendant wants, he affirmatively asked this court to affirm if it did not grant dismissal, so it should affirm. On the merits, Your Honors, it's true that the defendant himself denied selling drugs in order to get money to use marijuana. In fact, he accounted for where he got the money from. And actually, his own expert, when she was testifying, said that although he lacks insight into his drug dependency, he can be relied upon on factual matters. And he said that there's no connection. He said he didn't sell drugs in order to...
And she said he's unaware of his problem.
It's true, and that's another problem here. Another thing that would be dispositive is that one of the criteria is that the judge has to find that drug treatment will actually be effective. In this case, his own expert asked him, do you want to stop taking marijuana? And he says, I don't see any reason to stop. And this is when he had every incentive to exaggerate his willingness to participate in drug treatment so he could get diversion.
So you don't dispute that he probably does have a substance abuse order with the amount of marijuana he's smoking every day, right?
Yes, Your Honor. And the judge found that he said he definitely has a problem, has drug abuse.
That's just the start.
Right. He has to meet these other criteria, and he did not at all. So on the merits and on the relief issue, Your Honor should affirm. So if there are no questions, we'll rest on the brief.
Thank you. 1 minute, counsel.
I'd just like to respond to my adversary's comment about the treatment not being effective. This is based off the fact that Mr. Kirk attempted to quit a couple times and was unable to do so. That's normal for somebody who's addicted to drugs. And it doesn't actually show that treatment would not be effective. It actually leads to the conclusion that this is somebody who desperately needs treatment. And the fact that he lacks insight into his drug dependency is also not surprising. In the same testimony, the doctor said that while he gives quick, terse, one-answer responses to some of these questions, when he's actually kind of forced to go deeper into it, he actually does provide deeper insight into it. And
But I mean, counsel, even if we agreed with all that, the only thing we can do is remand, and you don't want that.
no, I don't. And I understand
I
that
would just say that, I mean, he was dealing around schools, which is a serious issue, correct?
yes, I don't mean to minimize the offense in any way, Your Honor. I would just say that when somebody's addicted to drugs and they're doing things that maybe goes against typical logic or reason, and in this circumstance, as I previously said, he, while doing it, said that he was thinking about how much marijuana he was going to receive and smoke because of it. So while the offense is serious, I will point to the fact that, as I said, he finished his probation, he showed a demonstration, the ability to build a therapeutic relationship with the caseworker from cases and with the doctor who spoke with him. And because of that, I'm asking for the court to exercise their discretion and
Thank you, counsel. Thank you both. Have a good evening.
Thank you.